Ms. Dyer, would you hide a certain thing right, yes, where no one can see them? Thank you. Okay, what's this committee called? Oh, yeah, the special committee. Call to order a meeting of the Special Committee on the Family Division of the Circuit Court of the State of New Hampshire. And we are privileged in having several members of the Circuit Court with us today. Just a reminder to those in the audience that this is not a hearing whereby members can ask to testify. This is a work session for the committee whereby we can have input from, in this case, the judiciary, to inform us as to what we might recommend back or even submit LSRs for future legislation. So we're very glad to have members of the audience and welcome you to sit silently and listen. I'd like to invite up Judge King and anyone you wish to bring. We can get more tables and mics if you wish.
Red is go? Okay, thank you. Good morning.
Back.
Yeah, like I have the gavel, that it's all backwards, yeah.
Well,
And you need that close to you.
okay. Well, good morning, Mr. Chairman, Madam Vice Chair, and members of this committee. Thank you very much for the opportunity to be here this morning. My fellow judges can introduce themselves when they speak, but just for the record, my name is David King. I'm the administrative judge of the Circuit Court, and I have with me this morning Judge Jennifer Lemire, who sits in Brentwood, Judge Susan Ashley, who's my fellow administrative judge, who sits in Rochester also, and Judge Michael Mace, who sits in Franklin, as well as Aaron Cregan, who you know is our general counsel. My understanding is there are 4 general categories that you want us to cover this morning: training, GAL/parenting coordinators, forms, and the rules of evidence. And if it's okay with the chair, I'd just like to make some preliminary remarks and then we can dive into the details. First of all, I want to thank you for all of the work that you've put in over the past many months. I know you've learned a lot about what the Circuit Court Family Division does, and particularly your focus on parenting and marital cases. And you've taken a lot of time to hear from many people over the last few months, and I know you worked over the summer as well, and we're very grateful for the time you've spent. I was especially pleased that every member of the committee took an opportunity to visit one of our courts last spring, and I hope that was educational, and I hope you got a chance to see how the Family Division operates in a real day and real time and got to meet some of the staff and see what happens behind the scenes. I'm sure, and I haven't had a chance, obviously, to be here for your hearings or to watch them remotely, but I'm sure you've heard from a lot of people who are unhappy with the Family Division, and that's not a surprise to me. And as I was thinking over the weekend about coming here this morning, I thought back to my own career that started almost 40 years ago, and I did a fair amount of marital work in my early days as a lawyer. And back then, we appeared in the superior courts. There was no mediation, so either you settled your case or you tried it in front of a superior court judge, or if you were lucky, in front of a marital master. And I would work hard to prepare those cases and do my exhibits and my requests for rulings and get the decision from the judge. And even when I thought it was a good decision, most often my client was unhappy. And so after a few years of doing that, it wasn't very satisfying work because I realized there's no making clients happy in the marital business. So this idea of having unhappy litigants from the divorce world is certainly nothing. It's not a new phenomenon. I'd like to talk real briefly about the resources in the Family Division because we've just released our 2024 schedule, and not here to ask for resources. I know this is not the forum for that, but I think the numbers are instructive to explain some of the complaints that you've probably heard about cases not getting heard fast enough or orders not getting out quick enough, people wishing they had more time for their temporary hearings and things like that. And as you consider legislation which could impose new deadlines, this obviously is a factor too. So we schedule, as I think you've all heard me say before, based on the weighted caseload. It's a statutory scheme that the legislature created. And for 2024, The statutory need based on weighted caseload is 13,303 days of judge time across the state for all divisions. That's all in with every case that we need to hear.
May I interrupt you to ask, with the addition of 6 judges, has this gone up now, or is this still a work in process?
So, Mr. Chairman, that number is irregardless of how many judges we have. This is how many we need. What we have, my next point, I think, will hopefully be illustrative on that. We have currently 41 full-time judges. We swore one in last Friday. We're swearing another one in Thursday. That gets us to 42. With all of our full-time judges, our part-time judges, our judicial referees, which are, we have 13 judges now over the age of 70 who are currently hearing cases. They give us as many days as they will or are allowed to give us. All in with everybody, we have 10,916 days to give. So we're short almost 2,400 days next year, calendar year 2024, which equates to about 9.5 judges. We have, just to answer your question, Mr. Chairman, we have one judge who's currently awaiting a public hearing next week. We have 2 unfilled vacancies that the governor has yet to fill. And then in the next fiscal year, starting July 1st, there are 4 more positions. So if all of those are filled, we'll be at 49 judges. And I think we'll still be short, but we'll be in good shape. But we have at least 4 known retirements next year, too. So it's kind of a revolving door in the circuit court. And obviously, as judges come on board, they have to be trained and brought up to speed, which we'll talk about training in a bit. Because so many of our cases involve statutory deadlines, however, and abuse neglect cases, guardianships, termination of parental rights, landlord-tenant, those cases have to get priority on our dockets. And where there's flex, it comes from the civil dockets, the small claims and civil cases, and the divorce cases. So when we need to carve out time on the docket to meet those statutory deadlines, it's those cases, the divorces, the small claims, the civil cases that have to get pushed out a bit. Another data point I'd like you to consider is that we get about 7,000 new marital and parenting cases a year, and we get another more than 4,000 reopened family cases a year. So add those together, that's the docket for the family division in the marital parenting arena. As you know, 85% of our litigants are self-represented. We don't have court monitors. You've heard concerns about the record. In the Superior Court, there's a court monitor that sits at the recording equipment all day long to make sure it's working properly and the microphones are working and all that. So when we've had instances where there are problems with the record, chances are the judge turned the recording on or the court security officer turned the recording on, and there's no one to monitor that during the day. And as you know, we don't have law clerks. So we have 3 staff attorneys, 2 today because one just left. Our judges write their own orders. Law clerks would certainly allow our judges to write more complete and timely orders. But the data point that I think is really important for you to consider is 7,000 cases, 4,000 to 5,000 reopened cases. In 2021, which is the most recent data I could get from the Supreme Court, there were 20 appeals from final divorce orders, 20. And there were another 42 discretionary appeals for other marital issues, which would be parenting, child support, post-divorce cases. So a tiny fraction of the cases that our judges hear, like way less than 1%, actually get appealed. And that's where, if there's a concern with a judge's order or what evidence got in that shouldn't, that's where those issues get sorted out. So I think that's a data point that tells you that, by and large, overall, the judges in the Circuit Court Family Division are doing a great job. I mean, if less than 1% get appealed, I think that's a pretty important data point. And you've certainly heard about a lot of cases that get drawn out for years. Perhaps in the courts, you were able to see some of the files of those cases that have gone on that take up, reams of paper. In 2014, we took a deep dive to look at our time to disposition. We found that there are 2 common threads that tend to make a case get long and drawn out. One are complicated divorces with lots of assets where there are closely held corporations and maybe a lot of experts, but more importantly, it's cases that involve disputes over parental decision-making and residential responsibility that can cause a case to go on for several years. That said, most of the divorce cases in the circuit court resolve quite quickly. About 50% close within 3 months, 70% within 6 months, 80% are closed within 9 months, and 87% are closed within 12 months. And of course, those that drag on for years take up a lot of resources and slow down the process for the cases that would otherwise resolve more quickly. So bottom line, I'm really proud of the work that our judges and staff are doing. That said, we know we can always do better. We look forward to working collaboratively with this group and talking about whatever legislative efforts you want to consider that will make the process go more smoothly. So unless you want to ask questions now, we can get into the sort of 4 categories.
I'd like to give the special committee a chance to jump in at various times. Chair recognizes the vice chair for a question.
Thank you. You spoke about the judges. I had never focused in all these years before on how understaffed the court is, not so much with judges, you're understaffed, but with clerks. I personally had no awareness that judges in the circuit court did not have clerks and other kinds of administrative staff. And I guess I'm kind of speechless. I'm shocked about it as I see it all. I see the effort you've made to try to use electronics to handle certain things, but no staff to assist the citizens who need guidance on how to use that equipment, for example. If you were to have an opportunity to bring more people in, would your first choice be to bring in more judges, or would it be to bring in more staff?
I think that's an easy question. It would be to bring in more staff. And that was our pitch to the Legislative Finance Committee this year. And actually, they were very good to us. They gave us 31 new staff positions in the circuit court, which is enough to do what we need to do. The problem is, as I sit here today, we have about 40 vacant positions that were vacant before the new budget kicked in. We very much want to fill those positions first because those sort of run the gamut from the entry-level positions to mid-level positions, and we want to sort out our internal candidates and get those experienced folks situated before we open up the doors to the outside, so to speak. And then we have those 31 positions. So we have over 70 vacant staff positions today statewide in the circuit court, which is, we had to close Candia, for example, because we had 0 staff in Candia. We posted several positions for the Candia court. We had no applicants. So we moved the family division cases to Derry, and we send a judge and staff members to Derry once a week to do the criminal docket, which there are venue issues in criminal cases. But we very much need to fill the staff positions that we have. I think all of our clerks would agree if we fill those positions with folks who are trained, because there's a pretty steep learning curve. Most of the people that come in the courts don't know what a plaintiff or a defendant is, for example. They don't know how the Odyssey case management system works. But once they're trained, if those seats are filled, we'll be getting orders out timely. The judges will have staff to process their cases. We won't have court monitors, which that's an expense that would be up to this body to fund. When a Superior Court judge goes on the bench, they have a court monitor. They probably have a law clerk, and they probably have someone from the clerk's office, most likely a deputy clerk who's a lawyer, in the courtroom with them. Our judges are often, as you probably saw on your field trip, in the courtroom maybe by themselves or maybe with a CA2 sitting to process paperwork, but it's a different
What was that? With
a court assistant, an entry-level court assistant.
Follow up.
If I could just follow up, the executive branch has a lot of vacancies. And the reason we're told the reason is because the salaries are too low. And then combined with the need for certain training. Or why do you think that you have 40 vacancies now?
I think it's a combination of factors. It's a competitive marketplace right now to attract people. Our number one budget priority in this session, which the legislature funded, was to raise the labor grades for our entry-level positions. We were at about $15 an hour for starting wage, and now we're closer to 20. So that is helping. We're seeing a little bit of a difference in most areas of the state. We're not losing people to Dunkin' Donuts and McDonald's, which we literally were before. As probably no surprise to this committee, the millennials who are looking for jobs don't care about health insurance because either they're on their parents' health insurance or they're never going to get sick. They just want to know, well, how much am I going to get paid by the hour? What's my paycheck going to be? And I understand that. So there are other businesses that are paying more hourly wages and don't have our benefits. We're not competitive with them. And it's hard work. We're paying these people not a lot of money to get yelled at the window. I've told this story many times, but we were doing second interviews in one of our courts, and we had the second interview candidates in the lobby waiting to be called in for the interview. And there was a person at the window in a family division case who was screaming at a court assistant because they were unhappy. And one of our candidates, who I think was the leading candidate, got up and walked out and said, I can't work in this environment. So it's hard work. And these are people that are responsible to make sure that arrest warrants are getting in the system. So if a warrant is vacated, somebody doesn't get arrested over the weekend. It's important, intense, high-level work, and we don't pay a lot.
Let me follow up to what you just said. Was there no one in law enforcement immediately or quickly available to stop this breach of the peace?
We don't. I mean, we don't engage. Certainly, don't engage law enforcement, and the court security officers are not going to. I mean, they may ask someone to calm down, but it's a daily thing in most of our courts. That's just the nature of the business.
Does it need to be with police presence?
I don't know. I'm not sure the police presence is, from time to time, the police do have to get involved if it gets physical, but I think these are emotional cases. People have the right to be emotional, and unfortunately our court staff are trained to try to de-escalate. We're working on that. We're going to do a training soon about de-escalation and dealing with these situations, both for court security officers and for our frontline staff. But honestly, Mr. Chairman, it's the nature of the beast.
Also, to follow up on money, did the 10% plus 2% raise that the legislature amazingly agreed to in the budget apply to court personnel?
Yes, it did.
So it's not just the entry-level position that got a bump, it would be other positions too?
That's true.
Good, thank you. Representative Ball.
Thank you, Chairman Pearson, and thank you, Judge King, for being here. I'm just wondering if there has ever been any effort between the court system and the Department of Education in trying to get students perhaps who are not looking to go on to college, but perhaps want to do an independent study, or we offer coursework in our high schools to try and pull students who might be looking for some type of a career in the law system or in the courtroom or courthouse, but not yet ready to move on to college. Has there ever been any talk about doing that as a way of bringing in more candidates?
Yeah, great question, Representative Ball. Not specifically with the Department of Education. We do send HR folks, or HR folks go to job fairs. I've said I'll go to high schools and try to recruit people myself. I mean, it can be a very rewarding career. Every year we do a ceremony for our 25-year employees, and you'd be surprised how many folks stay with us for a long time and make a career out of it. We have used summer interns. We had some this summer doing, more sort of routine processing, destroying old files, things of that nature. We recruit interns and externs from the law school. We're fortunate to have Franklin Pierce Law, I'm going to call it Franklin Pierce Law Center because that's what it was called when I went there. UNH School of Law, first and second year students who several spend the summers in our courts with our judges who they sort of work as quasi law clerks, and it's a great opportunity for them and it's helpful to the judges and staff. Even some college students who are thinking about a career in the law, we have no money to pay them, but we take them out for lunch once in a while and give them some exposure to the court system and an opportunity to network, and that's proven to be pretty beneficial.
I will do a follow-up.
Follow up.
Would it be something you would like to see pursued in working with the DOE to see if we can establish some type of a drawing system from the high schools to offer entry-level positions and training?
Absolutely. Any feeding network that we can tap into to get applicants to come to the courts would be wide open as far as I'm concerned. I'd be happy to follow up on that.
Thank you very much.
Judge King, I am aware of a report that was generated. We were told that a while ago, saying how many more judges are needed, and the criteria for making that recommendation, I recollect, had been changed to something that was much more realistic. Could you get us that report as we're thinking, not just thank you for the new budget, but the one coming up pretty soon? Could we have copies of that?
Absolutely. Would you like an electronic version? Would you like it in paper? How would you like it? It's about, I don't know, 90 pages. It's a pretty...
Paper.
Okay. Well, I'll make copies, and I can send an electronic version too, so that you have the option. The number is, I think, off the top of my head, it's rounded 65 judges is the need in the circuit court. We're fully loaded right now, 43.
Is there a Cliff Notes version of it?
There's an executive summary.
That's, I think, what
Yes.
it's properly called, yes.
Yes. And I mean, that was a study that we started back in 2019, and then this thing called COVID hit, and we put the brakes on because we didn't want to measure the need during a pandemic. So we finished it up. We actually restarted and did it. The only thing that I'll say to you when you review that, and the number, it's a big number, but bear in mind that was a study where every single judge and every staff member in both Superior and Circuit Court kept detailed logs every day for 6 weeks of everything they did. So I worked on a criminal case for 3 minutes. I mean, it was very detailed work. But in the Circuit Court, we measured things the way we do them. So a temporary hearing was 30 minutes because it had to be, when I think the two judges behind me that do this work would say, we really need an hour for temporary hearings. We just don't have an hour to give. So in some ways, we actually measured chaos, but the result is, I think, pretty illustrative of the fact that we're short.
With the committee's consideration on this, would we like the 90-page report sent electronically and the executive summary sent both electronically and in written form?
Yeah, that sounds great.
Sounds good. If we could have that.
Of course,
Thank you.
not a problem.
Any further questions, Representative Long?
Thank you, Mr. Chairman. Thank you, Judge. I'm looking more for data also on staff support. I know the $20 was effective July 1st, increase in the starting salaries. I don't believe, because of the work I saw them doing, that $20 is going to cut it. So I don't know if you have some rollover, how many people trained and worked for 6, 7, 8, 9 months, a year, 2 years, and left.
We do. We have some data on turnover. I can tell you, for example, in the information center, which is where all of our phone calls come. We started the information center in 2012. We just took our 5 millionth call this summer. We call them agents. Each information center agent takes about 100 calls a day. A lot of those are from unhappy people. A lot of them are borderline threatening. We've had death threats against judges that come in. I mean, it's a high level job. We have about a 60% turnover in the information center, which means for every 10 people we hire, 6 leave within 12 months. And an intensive training process to get those folks on board. The good thing about those jobs is they're, thanks to what we learned during COVID, almost all of the agents work remotely. So the $20 an hour goes further because they don't have gas expenses, for example, which is a way to attract people into those positions. Even though they're intense positions, we're hoping people will tend to stay in those longer because of the remote aspect of the work and the increased wages. But I agree, Representative Long, the $20 keeps us sort of, the executive branch all got the 10% raise too, right? So we're not stealing people from them. We're trying to steal people from law firms, looking collaterally where we can, for example, advertise in a paralegal brochure that goes to Paralegals Association to see if we can attract some of those folks to the court system for our benefits that law firms might not be able to offer.
Right. Quick follow-up, if I may.
Follow-up.
Thank you. So is the data accessible online or?
The
is-
HR data?
Correct.
No, but I can get that for you.
All right. Yeah, I don't need names or just how many employees, what the rollover is.
Yes.
I don't know if you did exit interviews.
We do exit interviews, not in every single case, but typically there's an exit interview. And I just round numbers, we have about 375 non-judicial employees in the circuit court. So 70 employees is, pretty close to 20% vacancy right now.
Very good.
Any
Thank you.
further questions on staffing or pay or hoped for staffing? Please continue.
Okay, then I think it's time for you to hear from the experts. If you want to indulge, I would call Judge Lemire up to talk about guardian ad litems and parenting coordinators, if that's...
I can do that in a minute, but before you go, I was under the impression that one of the reasons family court was started so that someone sitting in the courtroom who's very sad, it's a divorce situation, there's a lot of emotion, it could be sitting next to somebody in a criminal trial, and they didn't think that that was very good. I may have been given false information.
I'm not sure I understand the question, Mr. Chairman. I'm sorry.
The question would be, if you've got people who they're going to be hearings, this is before family court started. You are in circuit court, and the next case may be more of a crime than the one that was just a divorce. First of all, need to know if that was a fact.
So before there was a circuit court, before there was a family division,
Yes.
the divorces were in Superior Court.
Okay, so that would not be a fact then, what I just mentioned, as a reason to carve out family court.
No, I think the reason to carve out family court, and I wish Representative Lynn was here because he would agree with me, the Superior Court didn't want to do divorces anymore. So they were trying to figure out a way to get rid of them. They came up with the idea of marital masters, which was a help, but judges were still doing them. And so the idea was to create the family division, which was a pilot project in 1996 in Rockingham County and in Grafton County. And it was, I think, the longest pilot project in the history of the court system, but it went on for a long time. Eventually, under the leadership of Chief Justice Delanis, it rolled out. We didn't finish rolling it out until about 2 years ago when we finally closed the Plastow Court. That's when the family division rollout was complete. But the idea was the concept, and it's in the statute, was to have one judge for one family, which we've talked about before. That sounds great. In reality, it's hard to do for a variety of reasons. But the idea was to have specialized judicial officers, which would be originally marital masters who were specially trained in marital cases. Judge Lemire was a marital master. We had a robust marital master program, and then the legislature, as part of the circuit court bill, House Bill 629, I believe, in 2011, eliminated marital masters. We have no more marital masters. We had 13 when we created the circuit court. Tom Cooper was the last. He's now retired. The idea was that judges would be better suited to hear marital cases, and the masters weren't doing a good job, and now you're hearing about the judges that aren't doing a good job. So I don't think that was the magic bullet, but that
I
was
was attempting to lay a foundation, but I'm going to go ahead without one. And if this is not the time in this morning and someone else is to speak to this, please let me know. I am sensing some growing sentiment that domestic violence issues should be separated out from family court, even if that means two people are going to now be in two separate things, because the whole idea of domestic violence is just one negative on top of all the other issues that are civil issues. And that's the feedback I continue to get. I ponder that. I just wonder your thoughts on that.
I think in most of the courts, and again, we have courts that are really small, like Colebrook and North Haverhill, and then we have very large courts like Manchester and Nashua. I think in most of the courts, the clerks try to schedule domestic violence and stalking cases on their own sort of mini docket. In Manchester, for example, I think every morning there is a list of domestic violence cases assigned to a judge so that they're not interspersed with other cases going on at the same time. If that's what you're getting at, Mr. Chairman, I think we try to do that now. Oftentimes there's a criminal component of a domestic violence case too, which is not a
Wouldn't
surprise.
domestic violence be by itself a criminal case?
Well, the domestic violence protective order matter is a civil case.
Okay. Did you have your hand up, Vice Chair, on this?
I just want to ask you, Mr. Chairman, if what you were acknowledging as one point that Judge King just made, that domestic violence can be both civil and criminal, and so that gets you in different courts. But then in addition, in the divorce case, there can be a divorce issue and a domestic violence issue. Same principles involved, principles meaning AL, not LE, same people involved. And one of the realities is because people function in their own silos, it's possible that there is a judge involved in one part of family X's concerns that are before the courts, and another judge is involved in another part of that same family's concerns, and for many reasons, it's not easy for them to know what both the left hand and the right hand are doing. And I don't know if there's an answer to that. Is there?
Well, that's certainly true. The fact that many divorce and parenting cases have a domestic violence component. Ideally, the same judge would handle those. But again, for a variety of reasons, judges move. In the smaller courts, particularly on the front end of a domestic violence case where there's the ex parte petition, if it's filed, if it's a Colebrook or a Lancaster or a Case or North Haverhill, there might not be a judge in the county. So another judge that's going to get shipped electronically to another judge to rule on. The final hearing will always be held in the venue where it's filed, hopefully with a judge who will handle the companion case if there is one, but it doesn't always happen.
I will continue to monitor, and I will start better recording people who are bringing this issue to me with some narrative. This could be something at a later date for a conversation.
Absolutely, Mr. Chairman. And if you have a specific case with a docket number, we can take a look at it. We can look at the companion case and we can answer more specific questions.
And I would say to my friends in the audience, who at least two of you have very good networks of people who are concerned with these matters, I will be open to receiving such information by email. Thank you. And yes, Representative Long.
Thank you, Mr. Chairman. On the same topic, my understanding is the judges have access to criminal and civil cases, correct? So a family court judge can look into a criminal or civil with the litigants he's seeing in family court if there's a civil or criminal.
Sure. If I understand the question correctly, they can take judicial notice of another case. They typically don't do that on their own because we can't go outside the record of the case. But if a party said, for example, I want you to take judicial notice of this case and this docket number, that's allowable.
And a follow-up. if I may.
Follow up.
Yeah, I wanted, that was my next question, is that access helpful? Because we're hearing that of those situations and they're not checking the criminal records or vice versa. I don't know if that's an issue, but is that access helpful for a family court judge to know what's going on in those civil or criminal cases?
I don't, I'm maybe one of the experts behind me who does this work every day can give you a better answer. My answer would be, it could be, but it might not be material or relevant to the case that's before the judge at that particular time.
Great, thank you.
Chair recognizes the clerk.
Thank you, Mr. Chair.
Thank you, Mr. Chairman, and thank you, Judge King, for coming in for taking my question. I think part of what Rep. Long is referring to is we've heard of instances where a temporary order perhaps was issued in civil court and family court, a protective order, and then another party will go file for a temporary order. The opposite party will go file for a temporary order in criminal court, and if they lie on the form and don't say that there's another case, you guys don't go and look it up. So then there's two conflicting orders against each other against the opposite parties. So it's not routine to look up. So what you're saying is unless a party asked you to look up this other case, you wouldn't on your own go to look and see if there was another pending case in the other court.
Staff should check Odyssey to see if there is a matter, but I'm not going to say that it happens every single time. The information would be available, assuming that the other case was entered into Odyssey. Sometimes one party goes to one court, another party goes to another court, sort of at the same time, seeking the same relief, and judges may issue competing orders not knowing. And if it hasn't been entered, there's no way we would know. But ideally, if it was in the system and we knew, that would be something we would want to take into account.
Follow up.
Approximately how long does it typically take to get things entered? I fully understand that you guys are really busy. So is it usually a few days, or how long is it generally?
I think I'm going to defer to Judge Ashley on that one because she has more administrative experience and is in the courts. Like a CBPO, a criminal bail protective order, those things of that nature get entered very quickly. We don't, I mean, do we sometimes miss them? Of course, there's human error, but they are supposed to get in, and the DV orders go in quickly. They go to the registry. We have staff that stay after hours 5 days a week to make sure those are entered. The FBI has really strict requirements for getting those orders into the database so that they're visible to law enforcement. So those kinds of orders are processed very quickly.
Judge Ashley, just want to add one thing to this.
Just on the issue of the domestic violence civil orders, those are definitely entered into same day. They have to be. So people can't leave until they're make sure that they're ordered and they're in the system, and they're processed. I would just add on the issue of being able to access other matters, and you've mentioned particularly criminal. The court does not do record checks of folks so if two litigants are before us, we are not doing a blanket record check of all of their histories. That is really beyond our province when we're hearing a particular case. So someone, as Judge King would say, might ask us to take notice of something because, again, there might be an order of protection in a criminal charge. So the state's brought a case, there is an order of protection, it's a bail order of protection that exists. And it's important for us to know that when we're dealing with a domestic violence case, certainly to know that the defendant is facing criminal charges. But we don't always have that information before us. And again, we're hearing what folks are bringing to us and bringing to the table as they're trying to prove their burden of proof in the case, if that's helpful.
Thank you. Anything further? Then thank you. And Judge Lemire.
Thank you. Good morning. Good morning, Chairman Pearson and the rest of the
Subcommittee. It's such a pleasure to be here. I am going to speak in just a moment about really some of the resources we do have, some resources we might like to have in the family division with respect to, in particular, high conflict parenting cases. Briefly, just a little bit about me and how I got here. I am a native of New Hampshire, grew up in Northampton, and went to law school in Boston. And I came back to practice law here in New Hampshire. In 1995, I began my practice, and I practiced in New Hampshire, Maine, and Massachusetts, primarily family law, but also a general civil litigation practice. I practiced for about 14 years before I was appointed to the bench as a marital master. And that was in 2010, January of 2010. I began that service and enjoyed it very, very much. But as you heard Judge King say, by 2011, that was when the circuit court was formed. And as part of that, marital masters were no longer going to be part of that system. I was appointed, fortunately, and I am honored to have been appointed as a circuit court judge towards the end of 2012. So I have been a circuit court judge now for 11 years, and I've practiced in Manchester was where I began, and that's where I served for 3 years as a marital master, hearing solely parenting and divorce and other types of family division cases, 5 days a week. And then I sat in Portsmouth for 3 years, and then Dover for 4 years, and I've been in Brentwood now for almost 4 years. I also just wanted to say that I was very fortunate growing up, and I was reminded of this when Judge King spoke about our staff, who are fantastic. It would be wonderful if we could maintain the experienced staff, few that we do have, for as long as possible, because that institutional knowledge is incredible and important to have. My mother was a staff court assistant in what used to be called the Domestic Relations Department of the Superior Court. She started out in district court in Hampton, and then in Rockingham County, she was a court assistant in the Domestic Relations Department, and she was there for more than 35 years before she retired 20 years ago now. And it was through her that I gained an affinity for the law, for the court system, for the courthouse in Brentwood in particular. So it's especially, before she retired, she did work a little bit in I still call it the new courthouse in Brentwood where I sit now. It was 1996, I believe, when they made that change from the old one on Exeter Road. But it's almost like coming home for me to be sitting where I am now, and to be serving the people of New Hampshire in the way that I and others of us who serve in the family division are trying very hard to do, and we're trying to do the best that we can.
Is the court one of the divisions that is going to move over to the new building?
No.
Okay. So yours isn't leaking and yours does work, sort of.
I'm not sure I understand that question.
As a county rep from Rockingham County, I have eyes on that complex in Brentwood and the new one that's being built, because some of the old one should be demolished. So I just wondered if your part was working okay.
It's working okay.
Okay, good.
As far as I know.
Continue.
As far as I know. Sometimes I'm the last to know, but as far as I know. I also, I'm very involved in the training of the new judges that come on. I spend 3 full days just myself with them on many areas of family law, and as much as I can impart upon them from my own knowledge and experience when we do have new judges come on board. I'm a member of the Judicial Conduct Committee, and so I see another side of what we all do in that context. I value that experience that I have very, very much, and I think it also it helps me to continue to do the work that I do the way that I do it, and I hope that we can all use some improvement, and I hope that I am helping
the system as much as I possibly can, because that is my own aspiration. I am married. I have 3 adult children. I have 1 grandchild. I just had my first grandson born in May of this year. So that's just a little bit about me. But now I want to turn to a very important topic that I understand is one that you're interested in looking into, and that is the use of, or perhaps what might be a future use of, more mental health professionals and other types of professional resources within the family division in high conflict parenting cases. These cases are just a part of what we do here in the family division. I'm not going to bore you. You probably have, unless you ask, I would be happy to expand on the types of cases that we do here within the family division, but this is a part of them, but this is a very, very, very important but often challenging part of what we do as family division judges, is to hear cases where there is high conflict at times between the parents that are going through probably one of, if not the most difficult time in that family's life. And it is perhaps even more so for the child or children that are involved in those cases. As you've heard and as you've discussed and as you've mentioned, there is a lot involved beyond just the law. There are emotions involved, there are tensions, there is distrust, there is a lot involved in the dynamics of these cases. And we as judges do the best that we can with the law and following the law and the case law and the statutory law in New Hampshire. But when we can utilize other resources to help a family, if we're able to do that, then we want to be able to do that. Our statute, as you know, 461A, was something that was enacted in 2005 now. I still call it the new statute because I started practicing in this area of law in 1995. But it's the statute that, as you know, governs parental rights and responsibilities in New Hampshire. It was a sweeping overhaul of the law back at that time. It was the Parental Rights and Responsibilities Act that was enacted by the legislature then. And there was a task force on family law that did a 2-year study at that time, and it resulted in this new statute. And it began a way of looking at these cases differently. I still remember it quite well when it was enacted. We tried very hard to stop using words like custody and visitation, because what it did was it created, at least the task force thought at the time, a win or lose type of dynamic, as opposed to giving parental autonomy moving forward in these cases. And so there was a shift towards wanting to help parents, help parties make their own decisions if they can in a safe and healthy way that would then be in the best interest of the children. But there's always a difficult time doing that when we're also working within what is an adversarial system, the courtroom, with a petitioner and a respondent. We may call them petitioner and respondent as opposed to plaintiff and defendant in the family court setting, but still it's one party and the other party. But what we have is 2 parents, and we have a child or children and a family before us. So as judges, the statute requires that we support frequent and continuing contact between each child and both parents, unless it can clearly be shown to be detrimental to a child to do that. What we do is when they first come to court and they file their petition, we have what we call a first appearance session, and we explain the court process to them, particularly if they don't have attorneys or one party doesn't have an attorney. We refer them to mediation, because now under the statute, mediation is mandatory in cases involving minor children unless a certain exception applies. And we try to help the parents to resolve the issue on their own with the assistance of a trained mediator. And if they can, many cases do. Many cases settle even before they reach that point. When they file, they've got an agreement because they have done that, reached that cooperatively beforehand, or they resolve the case in mediation. But there are those cases, and these are the very challenging ones, where the parents cannot, maybe they cannot communicate, will not communicate, or they communicate in a very healthy and sometimes just horrible way with one another that most certainly the children are experiencing, I have to imagine, outside of or within the home or homes. But we have to help the parents create a parenting plan that is really the roadmap moving forward for how they're going to raise that child or children together, even though they're in now separate households. And it can be quite challenging with some cases. And so when they cannot do that on their own, then it's up to us as the family division judges to create a parenting plan that's in the child or children's best interests, taking certain factors that are in the statute into consideration. But we can only do that with the information that we receive from the parties themselves, because we have to make factual findings, and then we have to apply the law to those findings to determine what's in the child's best interests. Some cases, a party or a parent or the other parent, or maybe even both, have mental health issues, maybe substance use issues. There may be domestic violence and a dynamic involved that makes it difficult for a parent, especially one that's representing him or herself, to present evidence or information to us to help us make that decision. In our statute, 461A, then, there is authorization for us to appoint, we may appoint a guardian ad litem to a case. A guardian ad litem might be appointed in such a case because we have determined that the child would benefit from someone, another party, going and talking to the parents, talking to the parents' references, talking to the children themselves, making a report to the court with information that we cannot go out and get ourselves, and that for whatever reason we may not be getting from one or both parties. Ideally, it sounds fantastic, but in reality, most of the cases that need a guardian ad litem cannot have one because the parties can't afford a guardian ad litem. And we cannot appoint one if the parties can't afford to privately pay for a guardian ad litem services. We used to have, many years ago, a GAL fund similar to the mediation fund we have now for indigent parties to be able to have that service in their case, but that has long been gone. And so there is no option now. And a guardian ad litem is quite expensive. Often the hourly rate is about $120, but it could be less and often more than that. And when we appoint a guardian ad litem, we'll put a maximum, a cap on the fees they are to charge. But as many people who have difficult cases know, that last a very long time often, unfortunately, and the guardian ad litem has a large job to do, takes many hours, and in some cases it could be several thousands of dollars for that resource to be available. And then that person reports to the court. And it's evidence like any other evidence we receive in the case, and we give it what weight we believe it deserves. The parties are able to cross-examine the guardian ad litem and question the guardian ad litem's report, but it's not determinative. But it can be very helpful. It's just that we can't use it as much as we would like to. The other thing that we have is, I spoke about mediation and mediators, but in some cases, if the parties can afford it, again, this is a financial issue to a large extent, we will employ outside mental health professionals. And that may take the form of a counselor that will work, hopefully the children, if they need it, are in counseling. The parents often will come to court and inform me that the children are already in counseling, and I'm always happy to hear that. And that's something that needs to be respected and protected. But then what I'm talking about is a counselor that might work with the family as a whole, or with the children and the parents, or something that is called a parenting coordinator, or sometimes a co-parenting coach that would work with the parents in particular, because many of these parents in this small subset of cases that are very high conflict cannot communicate with one another, cannot, maybe will not, maybe one is trying really, really hard and the other just won't respond, or responds in an unhealthy way. So someone that is usually a mental health professional, a counselor, or perhaps an attorney might provide services as a parenting coordinator that would work with the parents specifically to try and educate them on healthy co-parenting, communication, facilitate that, encourage that, and try to manage that. But that, again, is something that's not often covered by the party's insurance. We always check to see what they have available for insurance coverage with respect to counselors and the like. And there's often a healthy out-of-pocket expense for that, and many people simply can't afford that. We don't have anything like that in-house, of course. You've heard the numbers that Judge King shared with you about what we have in terms of our court staff as it exists today. In a perfect, not perfect, but in a more ideal world, we would have enough money to be able to create a court system that would have some in-house professionals to assist. I went to a conference of judges this spring with judges from all over the United States and outside and other countries. And I learned about some incredible work that they're doing with overhauling their court systems. A lot of it was spearheaded by COVID-19 and in 2019, 2020, when things became very difficult and they had to really look at how they were handling these cases, making sure that they were being treated as they should, and that these people their situation isn't changing just because there's a pandemic. In fact, it created a whole nother set of difficulties within the family dynamic. And they still needed to be helped by the court system. So for instance, in Los Angeles, they have rehauled their court system, and they have court services officers now. They hired 10 right off the bat. They're mental health professionals who, when a case comes in with parenting issues, they screen it and triage it right at the beginning to determine what resources does this family need to help them through this process. Australia has completely overhauled its family court. And it did take $235 million from the legislature to do it. That was all of Australia, mind you. But I've spoken with judges there who helped and worked. They worked very closely with their legislature to make this happen so that they were able to bring in professional mental health service people who work now as court employees, and they're seeing tremendous results. And in the long term, it's helping their families, and it's helping the courts be more efficient. But most importantly, it's helping the children. Yes.
Would
Chairman
you
Pearson.
speculate that an experiment in one county with this might be funded, especially a smaller county? That thud you heard was Representative Weiler, head of finance, picking himself up off the floor. But if we did this in a smaller county with such a triage, with a few resources to see how it works, would that be something that might be a good idea?
I think it would be wonderful. I was.
That was a leading question.
And that's all right. I'll allow those today.
Thank you.
You know, I can't speak for everyone within the family court system, nor am I here attempting to do that. But I have been doing this a long time now, and I've worked with I don't know how many thousands of families, and I'm just one judge, but I have found in my experience that, and even more so of late, that to have someone more qualified than I in child psychology, in family dynamics, be involved with help with the case is of benefit. And that's not to say that the times that things of that nature have been employed have always worked perfectly. They certainly haven't, as you might imagine. But I have had cases before me where the parties agree. The parties agree. They may have attorneys. The attorneys agree that something has to happen. Something needs to change. Somebody needs to help this family. And it can't just be the laws of the state of New Hampshire or anything that I have the authority by statute to do. And they agree that I can appoint someone to come in as a family therapist or somebody, a parenting coordinator. I don't know that I've ordered that there be one if the parties haven't been in agreement, because, and I think that a mental health professional who does this type of work would tell you it's not likely to be successful if both parties aren't on board with it. When thinking about this issue, I was reminded that there are some folks within the state of New Hampshire in the mental health community and attorneys who do primarily family law, who do offer parenting coordination services. I don't think that they're often employed, but again, I think it's the financial piece in many, many cases that makes that difficult. Yes, Representative Katab. Am I?
Representative
sorry.
Katab.
I'm sorry.
Thank you,
Did I
Chairman Pierce.
pronounce your name correctly?
Yeah, and thank you for taking my question. So right now, besides parties just agreeing to do the parenting coordinators, is there any that I couldn't find? There wasn't a statute that necessarily allowed the court to order them to do so, right? Or
No.
did I miss something?
No, there is a provision within RSA 461A that speaks to, and it's in the creation of the parenting plan itself. I think it may be in section 6, towards the end of the section, Roman numeral 2 or 3, I think, that speaks to the fact that if we are going to order parties to have, or the family to have any counseling, that we need to look first to whether or not that's covered by insurance. And try to select someone in the first instance that's covered by the party's insurance. I don't know that there's another express language section within the statute that speaks to that, but there is at least that much that I know. And so, from my perspective, there is also, let me say this though, there is also some language within the statute. And also, it appears, I think, in the statute concerning guardians ad litem that allows the court and or the guardian ad litem in appropriate cases to bring in outside resources to assist with the family, but doesn't specifically say parenting coordinator. And I think parenting coordinator, at least as far as I know, is a term it's been a trend nationally in the last few years, and it's not something that has always, at least known to me, in the court system, but I think it's gaining traction. I know that in some jurisdictions, the parenting coordinator may be appointed by the court to do the things that I've mentioned, but also serves as somewhat of an arbitrator in terms of being able to make a binding decision that keeps the parents out of court. But helps them make, if they can't make the decision by agreement with that person's assistance, that parenting coordinator can then make the decision and they're bound by it. We wouldn't be able to do that as New Hampshire judges. There was a case in 2020 from the New Hampshire Supreme Court, Camille, Kamil, and in it, the New Hampshire Supreme Court indicated that we cannot parental rights and responsibilities and making determinations of parental rights and responsibilities is something that we are statutorily authorized to do as judges, and we can't delegate that authority. So we can bring in or ask the parties or order the parties to work with a counselor or a parenting coordinator, but what we can't do is say, and that parenting coordinator's decision is final on any particular issue. There are some jurisdictions, I think that Minnesota is one of them. They use something called a parenting time expediter, which is, as far as I can tell, akin to a parenting coordinator. And they have the ability to make binding decisions like that. I don't think that at least under that case that's just come down, not just, but 2020, it's recent to me, says from our Supreme Court says that we can't delegate that responsibility.
Follow up?
So I did see in the report that you were actually referencing from 19 years ago, the recommendation to have a parenting coordinator. So I did actually put in a bill regarding that. And it was in the sense of the parties agreeing to go, which was recommended from several family law attorneys. Well, if you want the parties to go in and agree, but you're going to want to keep the information confidential. Otherwise, the parties are never going to agree to be using this if whatever they're saying can kind of be used against them, which is, I think, the flip of kind of what happens with the GAL model. But I guess I'm curious about one thing with the GAL model that I've heard come up a lot, and I'm wondering if it may end up happening with the parenting coordinator model. Overall, with the number of cases that you've seen, do you see cases being swayed one way or the other when when one of the parties is paying for the GAL and the other isn't, because I'm wondering if the same may become true in the parenting coordinator model. And I guess I know that's going to be kind of an anecdotal question, but I'd really love your opinion on that, because you probably know which party's paying for it and you probably know the outcome of many of these reports.
I think that's a very good question, and I'm aware that many people feel that way. I think that it would ideally be that in every case, if there's to be a guardian ad litem appointed, the parties can both afford it and we would have them share equally in that expense. Then everyone has the same stake in the process, I think. And then, you know, I think that would, we would hear much less of that sentiment in that case. However, what often or what sometimes will happen, one parent will want a guardian ad litem to be appointed, the other parent will not or cannot afford it. Or one parent may be the parent that for which a guardian ad litem is really necessary, because perhaps that parent is the one who wants to move with the child across the country and that would severely impact the amount of parenting time that the other parent would have with that child if that were to occur. But you need to have someone that can look into the school system there and what the housing would be there and do that kind of investigation that a guardian ad litem can do that the court cannot. But that party, the person who is not moving might say, well, she ought to be responsible for 100% of that guardian ad litem expense then, because that's the reason why it's necessary in the first place. And if you look at the statute, there is one of the factors that we are to consider when appointing a guardian ad litem is who is requesting it, in addition to what the finances of the parties are. It's very difficult if both parties cannot afford it to appoint a guardian ad litem. If it's really, if we determine that, boy, this case really needs a guardian ad litem, this child or children really need to have a guardian ad litem in this case to be able to present this type of information to the court so that we can truly, or better, try to make a determination of what's in their best interests. At times, if that happens, and the only way it can happen is because one parent can afford to pay more of maybe 75% or even 100% of that expense, the other party cannot afford it, but that's the only way you can have the guardian ad litem in the case. What sometimes will happen is the person that is not paying for it may complain that the guardian ad litem is really working for that other party. I can understand how they might feel that way. Or what also sometimes happens is that the party that's not paying for the guardian ad litem may be having the guardian ad litem's ear all of the time and sending thousands of text messages and screenshots and evidence to help the guardian ad litem understand what is going on in the case. And then I hear the party that is paying for it complaining, well, you know, he or she ought to be paying more because they're taking up all, you know, the only reason the guardian ad litem's fee is so high is because the other party. It's a no-win situation, really. Any way you slice it, when we make the initial determination of whether we're even going to have a guardian and then who's going to be responsible for paying for it, we have to look at all of those factors. We have to look at, well, do we truly need one? Can the parties afford it? If one or both can't, well, if both can't, we can't appoint one. If only one can afford it or one can pay more than the other, we try to craft the order on appointment of guardian ad litem in such a way, at least I do, that will perhaps limit the scope of the investigation to just what I'm interested in finding information about, given what I've heard to that point in the case as being the issues involving the child or children. We can limit the scope of the appointment. But ultimately, I think that the same is true for guardians ad litem, mediators, perhaps parenting coordinators, attorneys. Each of those types of professionals involved in a case such as this, one party may be happy with that professional and the other party maybe not. That is, as Judge King said, the nature of the type of work that we're doing, the nature of these cases. It may be justified, it may not be, but these are the only resources that we have at present, and we can only do what we're statutorily authorized to do.
A follow-up, Representative Katab.
Thank you, Mr. Chairman. So just to follow back up, but are you actually seeing that when one party is paying versus the other, that the majority of orders are in favor of the party that's paying, or are
No.
you not seeing that?
I can't say that I have ever seen that, or that that anyone's brought that to my attention.
Thank you.
The chair recognizes the vice chair.
Thank you. We have had discussed before this committee issues relating to a judge requiring, in layman's terms, it might not be the technical term, a mental health evaluation that can be very expensive.
Yes.
I don't question the need, but I wonder how we can require an individual who has come to the court seeking a satisfactory resolution to take the responsibility for other expenses. I mean, I'm not raising taxation without representation issues here, but I'm wondering where in a fair and just system we can require someone who appears before you seeking help to take on the responsibility of a significant expense.
It's a very challenging question, and it's a very.
That's all I ask.
I appreciate the question. This is how I see it. We need to create a parenting plan that's in the best interests of the children. And we start with the premise that the child or children should have continuing frequent contact with each parent so that they have, because both parents have equal natural inherent rights to parent that child as they come to the courthouse. Those are now competing with one another because they're now in court, and one or the other is presenting evidence that the other is somehow presenting a harm to the child. That harm could take many different forms. I have, I can't speak to the facts of any pending cases, of course, but in general terms, certainly over the many years that I've been doing this, there have been occasions where a parent has a very serious alcoholism problem, very serious substance abuse problem, may have been involved in motor vehicle accidents, may have been involving the child in the accidents, or may have what appears to be very serious mental health illness that perhaps is not being treated or had been treated, but currently that party is not treating as he or she has been recommended by their physicians. And it's how do we then, if the parents can't themselves agree upon a parenting plan and how they're going to share parenting time with that child or children, how do we as judges create one that will not present any danger of harm to that child? If a parent presents with, if we have sufficient enough evidence to believe that there is a serious mental health issue or a serious substance use issue, or may be one, the evidence is clear enough, because the statute says it has to be clearly demonstrated that it's detrimental to a child to order something other than continuing frequent contact with both parents. How do we not put guidelines in place or do something to learn what exactly the issue is, so that if it can be safe for that child to be with that parent, we can work that into the parenting plan. So it's similar to, judges will order, where it's appropriate, supervised parenting time. And as you know, they're now few and far between, but there are supervision centers that provide these services. In cases where there is evidence of some presentation of harm to a child, sufficient enough for that judge to believe that the parenting time should be supervised, then it's ordered to be supervised. If we can put safeguards in place that will protect the child, so that we can make orders that are in that child's best interests, so that if possible, that child can have as much healthy, safe time with each parent, then that's what we have as an opportunity to do. Only, however, if the parties can afford it. And I'm very, very understanding of that issue. If a parent is in front of us because they're representing themselves, often it's because they cannot afford an attorney to represent them. And then if you're going to add on that a guardian ad litem expense, counseling expense, supervised visitation expense, perhaps, we all understand that is something that may be insurmountable. They may not be able to do, but they file a financial affidavit with us for almost every hearing, where there is going to be some type of, for instance, if someone asks me to appoint a guardian ad litem, I cannot and won't do it until they have both filed financial affidavits sworn to under oath that explain to me what their financial situation is, so that I can determine if they can afford it and how to allocate it. The same is with respect to the counseling. I mean, there may be many, many cases where I would like to have someone have a mental health evaluation, but I don't order it because they cannot afford it. It's not covered by
Representative
their
Smith
insurance.
for a follow-up.
Thank you. I apologize. I thought you had finished before
go
when I
ahead.
began to speak, so
Go
please
ahead.
forgive me.
No.
I'm very troubled by this, and I want to ask two parts of this, if the chair would permit me to do that. Is there any, let's forget about Australia or New Zealand or Finland or Sweden, where I
Singapore.
think everybody's supposed to be happy. Is there any state where these issues are not before a court, but are in another venue?
Not to my knowledge. And I believe, I haven't studied every state, but I would believe that every family court in the United States is experiencing these same issues, these same difficulties, which have only been exacerbated in recent years, I think. The COVID pandemic has really created even more of a mental health crisis, I think, with families.
The chair asks the committee researcher to get us some information as to whether any other United States state in family court has the same difficulty of lack of funding, or is there a state that has considerable funding available for GALs and some other things like that? Thank you.
My answer comes from my own experience. I've been fortunate that the conference that I attended this spring, there was a grant, fortunately, that allowed me to go. It was the Association of Family and Conciliation Courts. And it was a judges conference, and there were judges there from all of the United States and beyond, as I mentioned. And I spoke with many, many other judges, and I saw presentations by many judges from all over the United States. And what we were all finding is that we are all experiencing, or many of us, I should say, are experiencing a lot of the same challenges within our family court systems.
Do you wish to follow up?
If I could,
You may.
in my mind for these months is a comment that was made before this committee by one of your former colleagues, Ned Gordon, who said that we have to understand that the responsibility of the court is not to solve the underlying problem. And I have, over the years, whatever hat he was wearing at the time, found Ned's comments to be astute. I recognize the correctness of what he said, which causes me to say, then what are we doing? And I don't see the answer. Are we in fact helping families who are experiencing difficulties get to a point where, although we're not solving the problem, we are making it possible for the state interest? The state's interest is not in the marriage. That's a business arrangement. It always has been for, since time began. But in protecting children, and is there a better way for us to protect the children? You don't have to answer, but that is what I'm struggling with.
I'd like to answer, and I'd like to have more conversation with you about this because it's something I am extremely interested in finding out for myself. I understand intellectually, I understand why we have these cases before us. I understand that the state has a parens patriae power when minor children are involved. And that is why when parents who have these equal natural inherent rights to parent their children under the Constitution, when they are at conflict, when they are at odds with each other, why then we are employed to settle that dispute, so to speak. And then the question is, how do we do that? And what is the best way to do that? Of course, we have to be guided by the statutes, by the legislation that we have that enables us to do what we do. The case law that comes down from our Supreme Court, certainly, which interprets that and helps us in what we do. But ultimately, it's a parenting case, a divorce case with children or a parenting case is extraordinarily different than any other type of case that we see within the circuit court or that the Superior Court sees. And it's different for a myriad of reasons I don't need to explain to you. You all understand why. And so it doesn't fit as neatly, perhaps. And it isn't as easy, I would argue, to be a judge on these types of cases as in, say, every once in a while when I was on the regular docket of the circuit court, I would have to sit in district division and do criminal arraignments and things of that nature. And sometimes I did the civil docket and I heard small claims actions and payment hearings. And I looked forward to those days. They were a nice break because these are difficult cases.
Judge Lemire, I'm going to have to break in now with others going to be called forward. Sure. On October 17th, which is a Tuesday at 10:30 a.m., the subcommittee / work group of the special committee will be addressing the issue of GAL and parenting plans and all of that. It's the only subgroup I don't have in my notes as to who's on it. Anybody here? Or the clerk is my external memory stick.
So I'm chairing it, and it'll be Rep Long, Rep Greg, and Rep Lanza are also on it.
And who else?
Rep Greg and Long and Lanza.
Lanza, okay. So the four of you will be addressing this issue. And
Thank you, Mr. Chair, for indulging my philosophical, and I would just suggest that your other training might come in here, where perhaps the answer is to say, well, I'm going to divide the child. Thank you.
I have 2-day jobs. One of them is an Episcopal priest of a small church.
Yes.
The second one is part-time chief executive officer of a wellness center that has counselors and family practice physicians. So yes.
And I'm sorry if I spoke long on the issue, but
No, that's fine.
I
That's
I
fine.
very much appreciate Vice Chair Smith's your your interest. I was going to say.
Would it
I
be
appreciate
appropriate for the
very
members
much.
of the special committee work group to use you as a further resource?
I would be happy to have any opportunity to help if there is a way that we can improve upon what we already have in a way that helps us as judges, but more importantly, helps the families and children that appear before us.
So it won't go onto the broadcast recording. If you would either, if you're here when we adjourn, you can do it in person. If you have to leave, could you leave whatever contact information you are allowed to give them with the researcher, and they will check with her.
I'd be happy to.
Okay,
I'd be
thank
happy
you
to.
so much.
Thank you all.
Brief? Not a legal brief, just a short
Just a
statement
brief.
Okay.
Thank you, Mr. Chairman. Yeah, I would like that contact information. I have a lot of questions on the GAL and parenting that I'll reserve for when I have a conversation with you. But as we were talking, is this 95% or more just the high conflict, or is some of this tied into the 80% of the 9 months that get resolved? Is it?
No doubt there is some of it tied into the other 80%. But where we see the most need are the cases that do last the longest, that I don't have the expertise, the mental health expertise and what have you, to really therapeutically help these families the way that they may need, in addition to helping them as much as I can in the legal context.
Okay, thank you.
Thank you. Thank you all very much.
Judge King, who would you like to present before us?
Judge Mace would be next to talk about the rules of evidence. I just wanted Vice Chair Smith to know that I'll get this in the right order. Senator, Judge, Representative, now Referee Ned Gordon did 4 NCEs for us last week, and I believe all 4 settled. So he's doing a great job in his new role as a neutral case evaluator for the circuit court.
Doesn't surprise.
And the chair recognizes Judge Mace. And before you begin, sir, this committee is considering the question of rules of evidence. There are 2 bills before another committee I chair, Children and Family Law. Now, in a stroke of insanity, I appointed the same people to both groups because the clerk of the House said we could not have a joint meeting. So we cannot have a joint meeting of the 5 of us. What we can have is a meeting on 2 retained bills on rules of evidence in family court with Pearson in the chair, Ball, McMahon, Gregg, and Long, who amazingly then will remember what we did when we think about it here. So that session will be, I think it is on October 10th, next Tuesday, in this room. Children and Family Law, Rules of Evidence, Pearson, McMahon, who sends his regrets he had a family health issue. So you can mark him excused, Long, Gregg, and Ball. So with that, the chair recognizes Judge Mace. This, by the way, is what a paper printout of the Rules of Evidence look like. I didn't bring my own copy, and thanks to the Supreme Court for giving me a huge stack, the commonality of which is LexisNexis, which apparently I'm signed up for now. That has been read 4 times with the footnotes and even some cross-referencing to all those books who live over there. So bring it on, Rules of Evidence.
Thank you, Mr. Chairman, and I sincerely appreciate the opportunity to address this body. I am a circuit court judge, as you know. I sit in the Franklin Circuit Court. It's hard to believe now, but I'm entering my 6th year as a judge in October of this year. Before that, I was a civil litigator for approximately 20 years, 10 of which were devoted almost exclusively to family law in New Hampshire and in Vermont. I practiced in the Upper Valley. And apropos of our discussion today about evidence, I thought it wise to point out at the outset that when I practiced family law in New Hampshire and in Vermont. And in Vermont, the formal rules of evidence apply to those proceedings. So I have quite a lot of experience in both settings. And I can tell you with near 100% certainty that the general tenor of the litigation that Judge Lemire so eloquently described does not change whether or not the rules apply or not. So as a prefatory comment, we're still dealing with families in crisis, families who are going through trauma, and whether or not that is filtered to us through the rules of evidence or not is not terribly apparent to me, at least. So what I thought I would do for the committee, if it pleases you, is I wanted you to first be aware, if you're not, of exactly what kinds of cases we hear in the family division, what rules of evidence apply to those subcategories, and what burdens of proof we have to deal with, because those are all relevant when we talk about the rules of evidence. It matters greatly what type of case we're talking about, and it matters greatly what the actual burden of proof is in a particular case type. So the family division hears, of course, divorce and parenting cases. Judge Lemire was addressing those. We hear domestic violence cases. I think there were some questions of Judge King and Judge Ashley about how those are filed. We hear guardianship cases for juveniles. We hear abuse and neglect cases brought by the Division of Children, Youth, and Families for children who are suspected of being abused or neglected. We hear termination of parental rights cases. We hear delinquency cases, and we hear CHINS cases. Of course, CHINS is an acronym for Child in Need of Services. So in each case type, we have a series of rules and statutes that tell us what sort of evidentiary territory we're in. Starting with divorce and parenting, we have a Family Division Rule 2.2 that tells us that rules of evidence do not apply. It does not mean they don't exist. It just means that we can apply them when they would enhance, quote, the predictable, orderly, fair, and reliable presentation of evidence. So Rule 2.1 of the Family Division Rule tells us that those apply to divorce and parenting cases. Turning to domestic violence cases, those, of course, are parties seeking protective orders against the existence of a protected relationship, marriage, child in common, people related by blood or affinity, and the like. The rules exist, and that statute is RSA 173B3 Roman 8. The rules exist, but they're relaxed, which means that we're not bound by the technical rules of evidence. The burden of proof in those cases is preponderance. So you have to understand that when we're reviewing these cases, the rules do apply, they are relaxed, but it's preponderance. In other words, it's a more likely than not standard.
But there would be a ruling as to each particular bit of evidence offered.
Typically, yes. If they're conducted like most hearings you would expect to be conducted, we have 3 general categories of evidence we're looking for in a domestic violence case. We're looking for, first and foremost, the existence of a protected relationship under 173B. We're looking for a prohibited act, which is enumerated in 173, but it really mirrors some of the sections of our criminal code. And then, of course, the third prong, which is the most difficult, is whether or not the respondent in a case like that represents a present credible threat to the petitioner's safety. So it's in those 3 categories that evidence would fall. It's almost never contested that there's a protected relationship. It's generally pretty obvious. This is a married couple. This is a couple with a child in common. This is an adult with another adult child, for example. That would be a consanguinity relationship. So that we don't really get into too much trouble there in terms of evidence. It can get a little more complicated when we're talking about the prohibited acts. And I would add, importantly, it's really critical to note, and I think Representative Smith, you touched upon this, or forgive me, it might have been Representative Katab when you referenced someone seeking relief in another case type. It is often the case that someone who is a respondent in a domestic violence action is also going to be a defendant in a parallel criminal case. So it's best practices, and we generally follow this before we allow respondents to testify in these cases, we give them a general Fifth Amendment warning. They are public recorded proceedings, and anything they say on that record could be used against them in a separate criminal proceeding. So it's important, forgetting the rules of evidence for a minute, that you give them that general constitutional warning, because we are going to be talking about evidence on the record. It is a lower evidentiary threshold, but it is still a live proceeding, and we need to make sure that defendants that appear in those cases are mindful that they may be putting themselves into criminal jeopardy by testifying. The next category of cases is guardianships. These are juveniles or minors that are without appropriate parental care or supervision. It's generally the same evidentiary standard that we apply in domestic violence cases. We apply RSA 463(8) Roman 1. Again, the rules apply, but we're not bound by their technical application. There are two types of burdens of proof in guardianship cases of this stripe. If it's a guardianship brought by grandparents because of substance abuse, or it's agreed that, in other words, by consent, guardianship is necessary, the burden of proof is preponderance of the evidence. If it's contested, it's clear and convincing evidence. So it's that evidentiary burden that exists between preponderance and proof beyond a reasonable doubt. So that we again, in these cases, we're not bound by the technical rules, they apply. But if it's contested, we're looking at a much higher evidentiary burden. That typically means, as a fact finder, looking at the rules of evidence, we're going to be a little more on top of what we might let in under a relaxed standard, because the burden of proof is higher. In other words, it needs to be generally more reliable according to the legislature. Turning to abuse and neglect cases, these are brought by DCYF against parents and guardians for the suspected abuse and neglect of a child. We are looking at evidence from a statute. It's 169C12. That, again, is telling us that the rules are relaxed. There's one exception in that statute that's important to note. If the division brings forward prior, and I'm sorry, I'm looking right through the speaker at you. I'm trying not to ignore you. That if the division brings prior assessments or prior reports to demonstrate a pattern of conduct, the statute actually makes the admission of those reports mandatory. There's a shall in that statute. And that's an important evidentiary consideration, because those documents, and I can tell you with lots and lots of experience, Judge Ashley far more, they are racked with hearsay evidence. It is almost all hearsay. But those come in if offered to demonstrate a pattern, irrespective of whether the rules apply or not. So that's something we have to grapple with as well. The next section is TPRs, termination of parental rights. Those are brought pursuant to 170C. Again, we're talking about the same sort of evidentiary approach, but there are two, what I find to be distinctive features from an evidentiary perspective about those case types. In particular, the right we're talking about, the termination of parental rights is the most severe sanction I think we can issue as circuit court judges. It's the one we all fear the most. It is the most serious. We're talking about severing a fundamental parental liberty interest that has existed and has been recognized by courts across the country for centuries. It's embodied in Troxel versus Granville, which is a U.S. Supreme Court on point. So when we're dealing with the burden of proof, it is proof beyond a reasonable doubt. We apply the same burden of proof that we do to a murder case, because we are talking about divesting someone of a fundamental parental liberty interest for time and memoriam. So it's important to recognize that when we're in that subcategory of cases, we are dealing with proof beyond a reasonable doubt. The statute that applies to how we view evidence also has some mandatory language about confrontation. So if someone is going to be testifying to a report that they've made, they need to be on the witness stand and testifying live. So we do have some discretion about what we are going to let in, but the legislature has told us quite clearly we are at the highest evidentiary burden in those cases, and the testifying witnesses need to be testifying there live to what they've observed, not necessarily repeating what's stated in a report. Turning lastly to two somewhat related case types, we have 169B, which is our delinquency code, and we have 169D Delta, which is our CHINS statute. So the delinquency code, you can think more or less of our code of criminal procedure for juveniles. The formal rules of evidence do apply. It is proof beyond a reasonable doubt, and it's generally the same for CHINS, although in CHINS cases, we typically see a lot of evidence coming in without objection, because in those cases, we're typically solely focused on the welfare of a child. And it's usually brought, I wouldn't say all the time by agreement, but it does come in often by agreement or by stipulation or what we call a plea of true. If it's not, we do have the same evidentiary burden of proof. It is proof beyond a reasonable doubt. So that is, generally speaking, what we encounter in terms of the rules of evidence and the burdens of proof across each case type. I wanted to make that clear before I started taking questions, because what I've just listed with divorce and parenting, domestic violence, guardianships, abuse and neglect, termination of parental rights cases, delinquency and chins cases, those are a day in the life in the family division. And so you can see that we have to shift gears all day long between different evidentiary standards and different burdens of proof. And so it can get a little murky if we're not clear about what case type we're talking about.
Page 15 of Rules of Evidence say that evidence may be excluded if its probative value is substantially outweighed by the danger of prejudice or confusion. Does that hold all through your list, or are there items on there where weight is given a little bit more one way or the other?
I would say as a general proposition, that's all the way through.
Right.
I think that the difference, I think it's important to make a distinction between the application of that rule in front of a jury and a judge sitting as judge and jury. The danger of unfair prejudice, I think, my opinion, is lessened because we're trained lawyers and we're judges. We understand that someone may be throwing an exhibit in to try to inflame the trier of fact. As Judge Lemire discussed, in these cases, we see lots of inflammatory evidence, and we're very unlikely to be swayed by something that would be outweighing its probative value.
The comment of the jury will disregard what you just heard. Sure they will.
Right. I typically say, Mike, disregard that.
Questions? Representative Long.
Thank you, Mr. Chairman, and thank you, Judge. So you refer to a lot of the rules as relaxed. Is there a definition of relaxed?
Yes, the definition is actually from this body. It is that the technical rules of evidence don't apply. So when we talk about the technical application of the rules of evidence, you can think of, I heard someone was a fan of Law and Order. You can think of how these rules would be applied in a criminal case. In other words, someone would make a hearsay objection or object to a form of character evidence or bad acts evidence. Someone would be there trying to, you think of a tax fraud case, they'd be presenting a summary of voluminous exhibits and the documents wouldn't be in the courtroom. So if, let's take that last example. If I was technically applying the rules of evidence and I'm an expert accountant and I'm handing you a spreadsheet, if the backup documentation is in the courtroom, it's not coming in. So that's the technical application. I am standing on this book saying that's what the rule says. Relaxing it would be, let's say, it would happen in the complex asset cases that Judge Lemire referred to are a great example. If we have a closely held family corporation, for example, and we have voluminous exhibits, we've got lots of tax returns, bank statements, QuickBook printouts, and the like, sometimes the lawyers will agree that the summaries can come in without the exhibits being in the room. So I can relax that technical application by stipulation. That's one example of what it means to relax the technical application of the rule.
That's great. Thank you.
I would like to read into the recording the reporter's notes to Rule 102. And also it says New Hampshire is identical to the corresponding federal rule. This is reporter's notes, Rule 102. I don't have it, pages 6 and 7. The philosophical underpinnings of these rules, which are A, to prefer the pursuit of general normative goals to the strict construction of inflexible technical rules. B, to permit the court sufficient latitude to fairly decide issues where strictly constructed rules would tend to compete or conflict. And C, to favor the pursuit of the truth and a fair and just determination of issues over fastidious adherence to the letter of codified or common law. That pretty well says it to me. I mean, there's more statements further on in rules of evidence, but that seems to me the big ballpark of why in family court the rules of evidence do not have to strictly apply.
And I think if we're looking at this from a purely practical perspective, if we're forgetting all of the statutes that I referenced about the varying evidentiary standards and burdens of proof, if we think about best interests of the child, that is a pervasive theme through all of the case types that I just referenced during my testimony. It is particularly acute in any best interest determination we need to make in abuse and neglect cases and termination of parental rights cases. And it's important to recognize that our Supreme Court has differentiated between the proof beyond a reasonable doubt, that the DCYF must prove beyond a reasonable doubt the contents of the petition, or if it's a private litigant, the same standard, but that the concept of best interest of the child is not in and of itself an evidentiary fact. It's an examination of possible outcomes that are most optimal for the child, and we're instructed to give those priority. So in a sense, we can't really get at that determination if we're applying these rules, because we're not actually trying to establish matters of fact. We're trying to weigh outcomes for children. So it makes sense if you look at it from that framing that we wouldn't be bound necessarily by the technical rules if we're trying to get at the heart of a best interest determination.
The two retained bills that were submitted several months ago, but I asked my committee to retain them because I knew this was about to happen, spoke to issues of why does the judge keep admitting a motion to accept this evidence, that evidence. All it's doing is unnecessarily delaying. And I'm looking at Rule 403, the court may exclude relevant evidence if the probative value is substantially outweighed by undue delay, wasting time, needlessly presenting cumulative evidence that does not add to what is being considered. So there is a question that those are relative terms. Undue is not an objective thing. So how then would Family Division of Circuit Court take a look at issues where some would say too much evidence is being admitted in violation of Rule 403?
That's an excellent question. Beginning with some advice I got from a mentor who is an excellent trial lawyer who's unfortunately not with us anymore. She told me, who's my former law partner, that if you're getting everything in, you're in big trouble. In other words, if everything you're trying to offer as evidence is coming in evidence, it's not really mattering necessarily to the judge. That little quip aside, I will say that that is one of the more difficult tasks we have. My sense of why it's difficult is that when we're in divorce and parenting cases in particular, we're talking about the two things that are more important to us people than anything else. That is our children and the fruits of our labor. So you are going to try your level best to try to tell the judge everything you can think of to hang on to those two things. That is a very understandable human instinct. We try to be compassionate about that, but we have very, very compact, long dockets. You heard Judge King tell you about how little time we have to hear these cases. So that is one of those gray areas where we just have to make a gut call, discretionary decision on the record often, that we need to cut off a line of questioning, because we've heard someone say, this parent is a good parent, they bring in another witness, this parent is a good parent, they bring in another witness, this parent is a good parent. If we did all trials like that, divorcing couples would line up 57 neighbors long and we'd have month-long trials about a parenting case. We obviously can't do that. So it is one of those areas I just don't have a good answer for you, Representative Pearson. What I can tell you is that ideally, the judge that's hearing the case has trial experience and understands the limits of relevance and when it's kind of getting a little long in the tooth. It's been my practice, and I'm sure it's been Judges King's, Ashley, and Lemire's practice, that if you've gotten the point, you can tell counsel or the pro se litigant, I've heard you, I'm inclined to find that you have a number of people that are willing to say X, Y, or Z. So there's no bright line there, but it is something we need to be mindful from, and that is really a time conservation question, and I think that's right in 403, Representative Pearson. I think that's accumulation.
Representative Katab.
Thank you, Chairman Pearson, and thank you for taking my question. I have a kind of two questions in one. So regarding civil domestic violence cases that are not criminal yet, are constitutional warnings required at all? And then also, how does discovery work in domestic violence cases?
Those are both excellent questions. So the warning, I don't believe is required. I'm unaware of a mandate that we have as judges to issue that warning. I find it just best practices, and I know a lot of my colleagues share the same, that in the family division in particular, it is very common for us to see three cases co-occur: a divorce and parenting case, a civil domestic violence case, and a district court criminal case involving the same parties. Because we sometimes know that's out there, and I think you heard that it's not exactly an exact science that we are going to be aware of all three case types at any given time, but because there is the possibility of self-incrimination, there is a Fifth Amendment implication. We are the stewards of the Constitution in the courtroom, and personally speaking, I think it's important to try to uphold those rights whenever we are aware of them and can articulate them. And so if someone, particularly an unrepresented party, is sitting there and facing criminal charges as well, I don't think hurts to say, you know, you might consider you have a Fifth Amendment right against self-incrimination. It does leave them in a terrible spot, because having said that, they're going to have to elect, typically by themselves without a lawyer, whether they want to defend against it. And so I typically say, look, you are going to be in this position. I'm going to take this petition as uncontroverted if you don't testify, but it is your right not to. And it's at least important to acknowledge that right. So I don't believe it's a mandate, but I believe it's best practices. Did I answer your question?
Follow up?
Yeah, but I guess the part that I'm struggling with here, we are taking away somebody's liberties, right, in that process of doing so. And then we're kind of binding them, well, okay, you can choose to testify against yourself if you want or not, but we're also, I mean, there is a constitutional requirement, if we're going to take away somebody's liberties, that we are going to give them an attorney if they can't afford one also. So do we offer that ever in the civil cases, or we don't?
We do not. We are not authorized to offer that in civil cases, for the same reason we're not authorized to give divorcing parents lawyers. It's a civil proceeding. And as I mentioned, you know, maybe I didn't make it clear enough, but I do try to acknowledge that very difficult position that litigant's going to find him or herself in, which is that you may be deprived of a liberty interest to preserve a Fifth Amendment right in a criminal case. And it's an awful position to be in as a litigant. I certainly recognize that, but we don't have the statutory authorization to get around that. It just exists.
Follow up.
If a party, so I know that there is a clause allowing under the rules that if somebody is of good character, that they could be allowed to, I don't want to say represent somebody, but be allowed to go to court with somebody. And that's at the judge's discretion. So typically, if somebody doesn't want to have to testify against themselves because there's a Fifth Amendment issue, would you typically grant somebody's petition to allow somebody of good character to speak on their behalf?
So let me make sure I understand the question, because it's an interesting one. So if I'm a respondent in a domestic violence case, in other words, someone's brought one against me, and I bring a third party to speak for me, what is the third party telling me? I guess that's my question.
So I think they'd be able to at least ask questions of the other person and point out things that are into evidence without actually testifying, because they can say, according to this report, X, Y, Z, but they're not testifying that that's actually true, versus when the person's doing it themselves, they're kind of implying that they're testifying to that, right?
And that's an important nuance point, and I neglected to mention that. You can cross-examine the petitioner as the defendant and not waive your Fifth Amendment rights. When I see pro ses do that, I still give them that warning, because they may inadvertently incriminate themselves in the way they ask a question. So sometimes when you ask a question on cross-examination, you need to embed the question with particular facts that you want discussed. That's tricky if you really don't know how cross-examination works. So the answer is yes, you can preserve your Fifth Amendment rights and still ask the petitioner questions. It is, of course, far better to let a lawyer do that, but it's not always the case that we have that luxury. In fact, it's between 85 and 90% not the case.
One of the issues that has been raised to children and family law is the judge made an error in admitting that piece of evidence. And again, Rule 103, you've got to say, Your Honor, I object. And if I'm not mistaken, why? What is the nature of the objection? And I don't like it isn't valid. But it has to be done then, or in a timely manner. I think
Or
the
it can
wording
be waived,
is.
yes.
And the error is in admitting the evidence, the party objects in a timely manner with a motion to strike and gives the grounds. If the error is in excluding of evidence, the party informs the court of the substance of the evidence and why it should be admitted. But that has to be done in real time.
It does have to be done. in real
Therefore,
time.
if it is not, you've lost that right. Should it be appealed? The evidence is still part of what's being passed on.
That's a more nuanced question. I think that we're talking about two things. We may be talking about preserving the objection and preserving the issue for appeal, and then on the other hand, plain error. That even though someone may not have preserved a particular objection, they might have just said objection and maybe the judge just waved it off. If it was still plain error that it came in, it can still be addressed by the appellate court. But it is best practices, again, to have that discussion with the litigant objecting on the record about what the objection is. It's incredibly difficult, I'll say it that way, I'll use that strong language, with pro se litigants who don't know the rules of evidence. They may be saying, I object. It's my experience, it's often the case that the objection is a disagreement. It's not actually an objection, but if it is an objection, you need to try to suss out what they're objecting to in terms of its form and then trying to make a ruling on the record.
And if the judge makes an error that reasonable parties would conclude was an error on the part of a judge, if it's a harmless error that doesn't affect the decision would have gone the same way irrespective, then that does not poison things. Am I
Right,
correct?
that is the harmless error standard, correct.
Okay.
Correct. But it is the case that the Supreme Court can always look at an evidentiary ruling we've made and overrule us if we're wrong.
Now, here's my big ask.
Okay.
Because I've got to preside over 2 retained bill hearings that are coming at the rules of evidence. It seems to me from some of what we've been saying today and some other things we've been saying at other times, better instruction of pro se litigants might be in order, because I wouldn't have known these things. But people who are going to court and object, and the objection is incorrect, it's not timely, or it's not given reason for, may not understand that. Wouldn't they be hoped if in their own pro se preparation there was more information than provided? I've not looked at the videos, I've not read the documents yet, but it seems to me from the hearings that we've been conducting, nobody knew these things, and several other things. How would you think that might play out? That
I think more information is always better. This is designed to help us get at truth. That's fundamentally what this is. And so if we can better educate people that are appearing before us about how these apply, in what cases they apply, to what degree they apply, what burdens of proof they have, that is, I think, going to be an all ships rise situation. I don't see that there's any harm in that at all. The rules of evidence are difficult even for lawyers, but more information is always better.
Let me go further. Did you have a question? Okay. The separation of powers, because the legislature is making some, we guess, laws affecting the judiciary. So page 78, opinion of the justices, 1997, page 78. The legislature has no more right to break down the rules prescribed by the court to assure fundamental due process in criminal and civil court trials than the court has to prescribe the mode and manner in which the legislature shall perform its legislative duties. Wow. I'm trying to see where the line is. Reporter's notes on Rule 501, which is, as you know, the section on privileged testimony. I qualify under 502 medical and 505 clergy. So I'm really on that section. But the reporter's note on 501, which is the introductory section to that, page 97 says, although the principal statutory privilege recognizes the inherent right of the legislature to deal with such matters, provisions have been made, established in the rules, the saving for statutory privileges. Is that just for the 500 section, or is that for everything? Because I'm trying to put what I see is possibly contradictory statements about the role of the legislature.
So, Mr. Chairman, I believe you're talking about what our Supreme Court wrestled with in the Plouffe and Davis decisions.
I looked that one up, actually.
Those are very very difficult lines to discern in a separation of powers setting. So the best way I can think to answer that question is to reference my prior testimony about what you all have told us are the degree to which the rules of evidence apply in a particular case type and what burden of proof applies to that case type as a matter of statute. So that is clearly in the legislature's lane. How we conduct a hearing, in other words, how we interpret evidence, let in evidence, we're really talking about the lenses through which we view facts and establish facts. That is clearly a judicial function. So I think the line is somewhere between, and I confess it's gray, and I'm not convinced it's clear in either decision I referenced. But I would submit that when the legislature promulgates a law, the legislature is perfectly within its right to tell us whether or not particular rules should apply, and if, not if so, but in any case, what the standard of proof is. But once we get into the courtroom, how evidence is presented to the tribunal is purely a judicial function. And so the interpretation of the rules of evidence would always be within the judiciary. That's the best answer I can give.
The Supreme Court of which being the final arbiter, page 6.
The Supreme Court being the final arbiter.
So it sounds like a good collaborative effort here, where we're talking with each other and not at each other.
Absolutely.
Would be the best way to go forward, which is why I have several things in here thinking that a nice sit down would be preferable to our filing an LSR in certain things.
Absolutely. And as Judge Lemire made clear, we are always interested for opportunities where we can share those sorts of insights. We want to get it right. When you tell us that the technical rules are relaxed, and we have to go figure out what that means. If we have a dialogue about what that means, even better. Clarity is better than not having clarity.
And could I ask anyone who knows this, to what degree would that dialogue be permissible and not violating 91A?
I would defer to Judge King and Judge Ashley on that question. All right, well then, even better. I've got a lawyer right here.
Thank you so much. And would you drop off or give us, the 5 of us who are going to be looking at rules of evidence next Tuesday morning, or if you have to leave, to the research assistant, your contact information, because I'll give you 24 hours and then I'll call you.
I'm more than happy to do so. Thank you for the opportunity.
And one question, Representative
I'm sorry,
Wallach.
Mr. Chairman, forgive me. Oh, yes, I did promise to carry a point forward, and I believe I began with a discussion about being a family law practitioner in a state where the rules of evidence apply. If we're talking about procedural fairness, in Vermont, the rules of evidence apply to family proceedings. If you want to watch a pro se litigant go from terrified in New Hampshire to terrified and totally lost, apply the rules of evidence in a formal way. It makes it next to impossible for a pro se litigant to get a point across when the formal rules apply. So I would just leave you with that comment that the strict technical application of this book would make it 10 times harder for a pro se litigant to try a case, and we're dealing with 90% of the people.
So it's your testimony that Vermont and New Hampshire are not just upside down in terms of what they look like on a map.
And divided by a river.
Thank you, sir.
Thank you.
Yes, Representative Ball. Sorry.
Thank you, Chairman Pearson. I'm sorry, I
Was
just
that
had
for me?
one. Yes, please.
Yes, I apologize.
That's okay. Thank you for being here. One of the questions that kept coming up before us, and we were actually a little bit surprised, those of us who visited one of the courthouses, is the idea of presumption of 50-50 parenting. And we were surprised to hear that that's not always the case with the judges. Everyone seemed to assume that that was a presumption, that that's what the best interest of the child was, but was surprised to hear that that is not the case. So what I'm wondering is, if it's not the case, how is anything less than that warranted? And if you're the parent not getting, if you're getting less than 50% of the time, how do you present evidence to say that that ruling may not be in the best interest of the child? That was one part of my question. I'm just wondering what your viewpoint
Sure.
is on that.
Sure, the answer is actually in your question itself. So we deal with two subsections of 461A when we're looking at that. 461A2, which is the legislature's statement of purpose. We presume children do best when both parents have a meaningful involvement in their children's lives. Meaningful, of course, is not defined. So we look to 461A6, which are the best interest factors, and there are many. And it is in those factors that we weigh evidence about the time children spend with each parent as a best interest consideration. We're talking about a vast territory of evidence, and I can't give you any specifics because I would have to see a factual presentation to tell you how I would weigh such a determination filtered through 461A in terms of the best interest factors. But there's no presumption that exists currently. It tells us to take the 461A2 framing to go into 461A and weigh those factors against the framing. It may not look exactly 50-50. Sometimes there's a variance. Sometimes there's a very compelling safety reason where it may not be. Unfortunately, in the state, and I'm not talking out of turn here, we have a very serious opiate addiction problem, and some parents may simply not be suitable at a particular time for shared parenting. So that's a best interest factor we'd have to weigh. So it is very, very much a fact-specific and case-by-case determination.
Mm-hmm. I guess I'm thinking in that clean case where barring all of those extra things, that there seems to be sometimes the people that came before us to testify were not able to understand it. There was also one person who testified, and I'm just curious, and he said that he was found not guilty in a criminal court, but yet came to the civil court and lost full custody of his child. Is that something that happens? Or, I mean, that's where a lot of what was coming before us, just to clarify, is people were concerned that there was a weaponization of the civil court, and that's what I'm particularly concerned about.
The weaponization of court is something that we should all be concerned about. Abusing legal process is something we should all be concerned about. I mean, there's no doubt about that. I can only answer your question. I think you're asking me a specific question that someone, it sounds like, had a criminal charge and there was an acquittal that they carried into family court and said, hey, I was acquitted of what they accused me about. But you have to remember, again, this is why I was careful to lay out the burdens of proof. That's proof beyond a reasonable doubt. We're in the family division, we're typically at a preponderance standard. So that is another gray area that we have to wrestle with often. Now, if a case has gone to a jury and a jury has decided that something did not happen, that's something we would consider. That would be we were talking about judicial notice at some point. A litigator, if representing that party, would point out, mm-hmm. A jury of this person's peers has acquitted this person of this particular fact. We could notice that docket as evidence that 12 people took a look at it and said, no, it didn't happen. So we would certainly pay close attention to that, but I would have to know a lot more about how that presents.
I was just curious because that did come up often about the weaponization part. Thank you very much. I appreciate your time.
Pleasure to be here. Thank you.
Thank you. Before we move on to the next person, I have printed out on my own printer the complete rules of evidence that looks like that when somebody gives you one. And in terms of Representative Long, Gregg, or Ball, does anybody want this for next week? Does anybody my age want this for next week? You may have it. My copy is actually falling apart. I've been reading it so much. Yes, Judge King, who do we have?
We have training, which would be me, and we have Judge Ashley on forms. I know you're running short of time, so maybe
Well, that's my fault, and we only have, we meet next at 1 o'clock for things, so I'm willing to stay past.
Well, why don't we let Judge Ashley talk about the forms? That shouldn't take too long, and then we'll see where we are.
Okay. And do you have a 91A answer for me in terms of a few of us from the judiciary and a few of us decide to work things out nicely before we come public and announce it?
I have Attorney Cregan right over here.
Cregan, come
who
on up.
handles all of our 91A issues.
Good morning, Chairman. You may or may not know this, but the legislature has not assigned 91A to the judiciary. So the major operative concern when you're convening a meeting between the legislature and the judiciary is your rules. Thank you. 91A covers the legislature and the executive branch, but it does not cover the judiciary. We're bound by Part 1, Article 8 of the Constitution in our response to public records requests.
So we cannot, by definition, have a 91A violation if we meet with you.
Well, it's more accurate to say that the judiciary does not have a 91A violation. The legislature is still bound by its own rules on convening. So if you have a rule, for example, for quorum of members, you would have to be open. That rule would be observed by your rules.
I think fewer than 50% of us could have a wonderful meeting with you at some point. Thank you for that. Appreciate that.
Thank you, Chairman Pearson, and I appreciate the opportunity to speak to you very briefly on the issue of forms. It's the most exciting topic you can ever think of, so they saved it to 11:45. My name is Susan Ashley. I'm the Deputy Administrative Judge for the Circuit Court, and I know that this is an issue that was identified by your committee to address, particularly user-friendly forms, I think. And I'm happy to report that it's good timing because the judicial branch is actually on the verge of issuing an RFP seeking a vendor to assist us with forms simplification. And that is tied to part of the court's work with there's a fairly new entity that has been set up by the Supreme Court within the administrative office of the courts. It's the Office of Access and Community Engagement. That office is working in conjunction with the court's Access to Justice Commission. You may have all heard of the Access to Justice Commission. It's been in place for many years. Those of us who are part of the commission call it A2J because we always have to have an acronym for things. But the A2J Commission, it's about 30-something odd folks who are involved with it, members of the courts, members of legal service agencies, attorneys who are often community-minded and are interested in this, and it's focused on civil matters. So it's not a criminal focus. It's focused on civil legal issues and making sure that folks who should be able to have access to the courts can have that access to the court. So as part of the A2J's work, there was an application quite some time back for ARPA funds, and we actually received some ARPA funds earlier this year for 6 different projects, and one of those projects is forms simplification. And so we are at the point at this stage of issuing an RFP that is looking for a vendor who will assist the court in the process of identifying certain forms that we can make plain language, more plain language than they are at this point. Obviously, it's tricky because our forms do sometimes need to contain legal terms and concepts that can never be plain language because they are what they are. They've been legislated to be called whatever they are, but still the use of the forms can be improved for sure. So this effort is going to it's a certain finite amount of money, of course, that has been given to us through the ARPA funds, and it's going to look at which forms are the highest use forms that we have. And I should just say the court system, circuit court itself, has upwards of 1,100 forms. So we're certainly not going to make all of our forms user-friendly in one bite, but it's going to look at which forms we may be able to improve upon. It's going to have a family lens to it. I can assure you that, because that is where we hear of the most difficulty with some of our forms. Again, because these are cases that often do not have attorneys involved. They're going to identify which ones are most frequently filled out incorrectly. And that's sometimes they're not filled out at all, which is its own issue. But sometimes they're just complicated and folks don't understand what they're supposed to be putting into these forms. So they're going to identify what these are and take a crack at improving them. So the vendor would be looking at those, convening folks, convening subject matter experts to identify those forms, and then working on improving those documents themselves, including instructions for completing the documents. And then they would also be training court staff because, of course, we're always in the process of revising forms and potentially creating new forms if there's a statutory change or a shift. And so it would help us going forward as well. The work is going to be done, we expect, over the next 6 to 9 months. The RFP, again, is just going out. Hopefully sometime this month. So that process will go through its typical process, and then the work would begin in earnest end of this calendar year, we hope, and through the next 6 months. Simultaneously, the court is also, and we've been discussing this for quite some time, you're all aware that some of our case types are electronically filed. Our divorce parenting cases are not electronically filed, but we want to try to make an impact on those in a way that might be helpful by utilizing what we call a guided interview, which is used, for instance, if you're filing a guardianship case, you're taken through a guided interview where it tells you what information it needs, and then it will populate the petition and it creates the petition for you. This would be a guided interview for our financial affidavit. Now, you've heard the judges talk about the financial affidavit. It is a difficult form to fill out. It requires certain information. Sometimes folks don't exactly understand what that means for what's being asked. So this guided interview would be a way to have them input the information. It would explain more what we're looking for, and then it would do certain calculations so they can put in whatever their income is off of their paycheck, and then it's going to tell them what their monthly income is, for instance, so they don't have to do the math themselves. We have heard over and over from self-represented litigants and from lawyers who do these cases that this would be an extraordinary help to all litigants in family cases if we had this type of a guided interview. So there's some conversations that we're having to see how we can advance that technologically speaking, and we're hoping to work on that as well, again, over the next many months to see if we can create something like that would be helpful for that one particular form that is required for all of our parenting and divorce cases, and as Judge Lemire said, required to be completed frequently in those matters.
The special subcommittee on forms, chaired by Representative Gregg, Representative Mann, Ball, and myself are also members of this, meet next Tuesday at 1 p.m. My guess is we're just going to try to identify forms we keep hearing about. I don't suspect we'll move towards suggesting litigation or anything, but just being four friends of the court. So that's the timeline on this. We'll try to get our work done from all the things people came in and told us about, and
absolutely
pass them along, which will probably mostly just underscore what you already know.
Fair enough. Well, happy to have the input that you want to provide to us, and if we can provide any further information, happy to provide it. And I know you probably would like to hear from Judge King, so
I would like to hear
if
from
there are any questions. Otherwise,
else.
I can step back.
Quick,
If
I could get a quick.
you got a quick question. This is a brief question.
Thank you, Mr. Chairman. Is there some sort of public participation in this? Now, I understand that you will have, you're flagged, you have data as to what forms are complicated. But in these processes, is there some sort of public participation?
There's absolutely going to be public participation in these, what I was just speaking about, absolutely. We want the
great.
input from the public. Some of it comes through the A2J Commission members who work closely with various members, so it filters up through them, but also want input from folks who are using these forms, testing and saying, is this helpful and is this the right language to use? And also, part of this, I didn't get into it, but it's also going to be an ADA accessibility issue as well. So we want to make sure that the forms are accessible to everybody who needs them.
Right, thank you.
How would my friends in the back row who would like to be part of this, or in their networks of people, some of whom would like to be part of this, discover how they can have their voices heard?
We can provide information to you if that's helpful to you as to how they can get input on these forms issues. I can do that afterwards.
Good.
Okay,
Thank you, because I know they will want to do this.
great. Thank you very much.
Thank you. Judge King, are you going to be meeting with us at 1 about training?
I am.
Then we can have anybody else who wants to testify before that go now in case we run out of time. And then we re-adjourn at 1.
So anyone, I mean, I think the group that came with me, we're pretty much done except for the 4th topic of training.
Which we'll do at 1 o'clock,
Okay,
so there's no need for you to do it twice.
okay.
Unless you think, you'd like a dry run.
We need training, believe me.
No, I'm happy to do whatever the committee wants to do. I was prepared to just sort of give a thumbnail sketch of training, but I'm happy to do that at 1 o'clock and give everybody an extra 10 minutes. for
That'll
lunch.
give us a little bit of lunchtime, but before everybody goes, just remember those who we've asked, if you can provide us the contact information you're allowed us to have, would appreciate that. Also, we identified 4 different areas from all the documents that came to us, all the research that was done, all the people testifying. We identified 4 different areas, and we've covered them today. We'll be having our subcommittee meetings of the special committee and see what happens. My guess is that in some, if not all, we will have recommendations, or we would like to schedule a minority of us to meet with you in ways that are appropriate to 91A of the House. There may be a case or so where we would come up with an LSR and see if it'll turn into a bill, into a law. We have been granted the right, even though the deadline was 3 weeks ago for House file bills, we as a special committee have been given a deadline to early November. So if we're going to do that, we have that time framework. I've been told that there may be a few cases where the judiciary would actually want us to make a law or enact a law. Propose a law, because that would be helpful to you. And if that's the case, would like to cooperate with that. My guess is once we're done with these 4 areas, we're going to be taking a look at a few other areas. And I understand that there's been some conversation amongst some of the special committee members to see, do we need to have some more subcommittees and look at other issues, or is our work done and then we file our final report? I think that's still to be determined going forward. If it is determined that there's 1 or 2 other items, we've got November and December minus holiday periods to have a hearing and a subcommittee discussion on that. So that's where I think we're going. Anyone else from up here? Then I get to use this because incrementally I'm being moved to the law thing from we're done.
Thank you, Mr. Chair.
Thank you.
Private family law and wholesale law.
Yes.
I was
I would like to throw myself in front of that.
Good afternoon. The time being 1 o'clock on October 3rd. I'm going to call to order the subcommittee on the Special Committee on Family Court, which is looking at judicial training, education, supervision, and accountability. These are issues that came up in the series of hearings that we've had up until now, and we are quite honored to recognize Judge King, who is going to tell us a little bit more about this area. Judge King, thank you so much for spending so much time with us today. We know you don't have enough time to do your job, and here we are taking you away from your job.
Thank you. It's an honor to be here. I'm David King. I'm the administrative judge of the circuit court, and truly this is a topic that's very important to me. It's probably one of the more challenging aspects of my job as an administrative judge with 60 or so judicial officers with, I would say, pretty constant turnover. So I've kind of broken it into three components in terms of training. So component one would be the brand new judges that come to us, and then our ongoing regular judicial training for our existing judges. And then what I call, for lack of a better term, specialty training. And the example I'll use is the probate division, where I'm literally the only judge left in New Hampshire that was appointed to the probate court. And we've had some judges with probate experience who have been doing the probate work, but 3 of them are retiring. 1 just retired, Judge Weaver, 2 more shortly thereafter, and we don't have the bench. So I am recruiting existing experienced judges into the probate division, and we're putting together a plan. That's my next major project. So those are kind of the 3 buckets. And I think I know you understand this, but it's important to just consider that we don't choose judges. There's no process for us to vet candidates, executive branch. That's the way it should be. That's the Constitution. But I'm trying to think of an analogy. If you were a general contractor and you build houses and you didn't hire independent subs, you did everything, and you needed a mason, and somebody else was doing the hiring for you, and they gave you a bunch of roofers, you still have to take the roofers, but you have to figure out how to teach them masonry and, in a fairly short time, get them into the rotation so that you can build a complete house. We have to build the complete house in the circuit court. So as a result, we get judges with a variety of backgrounds. The governors have done an excellent job over the years of giving us good candidates, but if we're in a point in time where we need a lot of family division judges and we get 3 or 4 prosecutors in a row who are great lawyers and know the criminal stuff inside out, we still have to teach them the family division because that's our need at the time. Probate's another area that's really specialized. It's the only area in the judicial branch it's actually growing. Our criminal numbers are down, our civil numbers are down, but New Hampshire's a graying state, and so our estates and our guardianship numbers are going up. We need more probate expertise. Since we created the circuit court in 2012, hard to believe, but we've onboarded more than 50 new judges. I'm the only judge left, full-time judge left that was on the bench when we created the circuit court. My colleagues have all left me. There were 45 full-time judges and marital masters, and I'm literally the only one left, which I guess tells you that we've learned a lot about training over the last 12 years. We currently, as I mentioned this morning, have 13 judicial officers. I can't call them judges because under the Constitution, they're not judges anymore, but 13 judicial officers who are currently hearing cases who are over the age of 70. One of them, I won't tell you his age, but he's been constitutionally retired for 10 years. And he regularly takes cases in landlord-tenant and small claims. He knows how to run a docket. He's pretty efficient. He does a great job. And we use him because he's good and because we need all the days that he can give us. And just to put it in perspective, Governor Sununu has appointed 35 judges to the circuit court since he's been governor. So a lot of turnover. We also have a judge recently appointed whose retirement date is 2057. When I swore him in, I said, "I'll be dead when you retire," which isn't really funny, but it's the truth. I mean, and if you change if the Constitution changes to 75, his retirement date will be 2062. For sure, I'll be dead then. Even if I'm really lucky and make it to my late 90s.
I think Bob Lynn, if this passes, can serve for 3 weeks.
Yeah.
Oh, I'm sorry, and I didn't ask your permission. Excuse me.
The training of new judges is governed by Supreme Court Rule 55. We do it in-house. By and large, we rely on our administrators. There are 5 administrators in the circuit court. They're all attorneys. We have authorization for 3 staff attorneys. We have a newly vacant position as of today, so we actually have 2 staff attorneys in the seats. We don't have legally trained clerks. Our clerks, with 2 exceptions, are not lawyers. So it's the administrative judges, the administrators, the staff attorneys, and then judges like Judge Lemire who come in and do case-specific training for new judges. Because we don't have law clerks, we've had to find a different way to provide that service, which is also a big part of our training. So, for example, we have a listserv that's very active that all of the judges and the staff attorneys are on, where a judge can say, "Hey, I've got a landlord-tenant case with this nuance. Can anybody help me?" And, an experienced judge, usually within a few minutes, will see that and provide an answer. Or a new judge, "I'm going on the bench in 5 minutes. Can somebody call me now?" And there's always somebody that sees that and provides a lifeline to the new judges. So it's not really training, but it is training in the sense that that's a resource that's available for new judges who are constantly learning. We're all constantly learning as far as that goes. We have, when COVID hit in early March, I was concerned that we were canceling literally thousands of hearings, and there would be a perception, perhaps by someone from this branch of government, that we had judges who weren't busy. So every judge in the circuit court was given an assignment within a couple of days to prepare training materials. So Judge X, you're doing alimony, you're doing, predominated heirs in the probate court. Everybody got an assignment. Their job was to do a memo on the substantive law, a bench card that judges could have with a synopsis of what they needed, and a PowerPoint that we could use for training. And I think there were 50 plus assignments. And so kind of within the course of a month, we completely revamped our training materials that we use to train new judges. And a lot of those include recorded presentations that we've done. If we bring an expert in, if we can find the money and we can get their permission to record it, let's say it's on the brain development of children. We've had experts on that. Costs money to bring that expert in, but we can record that and put that into the bank of materials that we have. And so during the course of new judge training, a judge will be assigned to watch that video. And it's a way on sort of the New Hampshire way of doing things without continually bringing in speakers that cost money to capture that, because that's sort of a topic that doesn't change a lot with time, the science behind brain development. So we cover everything, substantively that we need to cover for training of new judges. We also take into account the skill set of the judge that's been appointed. So if we have a prosecutor, we know we don't have to spend a lot of extra time training on substantive criminal law, but that judge probably needs a lot more of Judge Lemire's time to learn the family. So we do not have a one-size-fits-all training for judges. And the training materials that we have are not static. They are constantly changing to keep up with the law. When you folks pass new laws and we need to do training on new legislative initiatives, then that's incorporated into the training materials as well. The training, so I'm happy to answer any questions about onboarding new judges. We have 3 in the pipeline right now. We have Judge Tanya Sponey, who was sworn in last Friday. She has a pretty wide background. She's done quite a bit of probate. She's done a lot of family, a little bit of criminal, and some abuse and neglect. So she's got a good background, which is kind of unusual today. We have Judge Dorothy Walsh, who I'm going to swear in Thursday morning. She's a prosecutor from Manchester. She's done a lot of domestic violence prosecutor, so she's kind of an expert on DV. And then Elizabeth Payne, Betsy Payne, was a former was the domestic violence expert in our operation for 20 years, I think. The first round of domestic violence protocol, she was the primary author. Her dad was Bill Payne. He was the county attorney in Carroll County for years and then became the Conway District Court judge. So she's going to be able to wear her dad's robe if she's confirmed. So she comes with, she now works for CASA as a staff attorney. She's been with them for a number of years. So she knows the abuse and neglect very well, and she knows the domestic violence. So when we put those three together in one class, there's a lot of cross-training that we can do just using the new judges to sort of educate each other during the course of the training too.
Question, I hope I'm not breaking your train of thought. When the document that you sent us said that newly appointed circuit court judges received 6 weeks of training, is that full-time?
Yes. And that's the ideal situation. And that's hopefully when the governor's been great working with us most of the time. These three judges are coming in like staggered over a period of time. And so ideally it's 6 weeks start to finish. And that's all training, 5 days a week for 6 weeks. It's a combination of at our administrative office, so sort of, if you want to use the word classroom training, it's self-study, it's mock trials that we actually have scripts and we teach them the trial work. It's time in the domestic violence registry, so they learn what happens when they issue an order, where it goes, how it's processed. We put them in the information center for a half a day just so they can hear the phone calls coming in, because I think that's instructive about issues that litigants are struggling with, so that they can sort of have that in their mind when they're on the bench. It's a lot of shadowing with experienced judges, and we've debriefed every class, if you will, over the last several years, and we've learned that what we've been told is that the best way to teach the substantive law is to have the new judge go to, let's say, a landlord-tenant session where they're going to see a whole half day of landlord-tenant hearings. And then the next day we give them the nuts and bolts substantive law on landlord-tenant. We used to do it the other way around, and for whatever reason it works best when they watch the hearings and then they get the substantive law. So that's all built into the schedule.
And who organizes that? Do you have a training coordinator?
We do not. It's a combination of me, Judge Ashley, and Heather Culp, who's our senior administrator. The staff attorneys are involved, but it changes because people come and go, and it's who has the time at the moment when a judge gets appointed. Again, we have no control over timing of judges. We'll take them anytime we can get them, but we don't have any control over that. So that's certainly something I'd love to talk about.
Thank you, Chair, for taking my question. Thank you for coming. So I wanted to ask, I guess, a multi-part question. So you had stated that the 6 weeks full-time would be an ideal situation, but I know that we're time constrained here, so we're not necessarily currently in an ideal situation. So I guess my question would be, how often are we actually doing the 6 weeks of training versus how often are we having to start the judges sooner because we need them to hear cases and the time isn't there for us to do that?
Great question. I think the short answer, oops, this goes off.
Oh, sorry.
Didn't know that. I would say I'm going to say 50-50, just to pull in, that's not scientific, but I would say half the time we have a big enough group, which I would say is kind of 3 to make it work the best, to just run it start to finish. We will get the 6 weeks in one way or another, but it won't be 6 continuous weeks with all 3 judges at the same time, if that makes sense. Nobody gets shortchanged on what they get. We might skip something. For example, we haven't done training on probate substantive law for a while because it's a very specialized area of the law, and the judges that do it do a lot of it. And now we're forced to do it because we don't have the probate division judges available. And the plan for that, just to share my thoughts, since, like I said, I'm it. And we've also had some very long-standing, one person who was with us for almost 40 years, who's been in the probate division forever, retiring. So a lot of our experienced probate staff are leaving. So it's a dual challenge. It's recruiting staff to the probate division and judges. And so have a recent 30-year deputy clerk who was a deputy probate register back in the day and has a extensive knowledge of probate law. She is going to be my partner in this recruitment and training effort of judges and staff, and we're going to do it together, meaning we'll be training staff and judges at the same time on probate issues. And the plan is, because it's going to be involving judges who are on the bench and have dockets, it'll be 12 to 1. We'll do it virtually, and we'll just pick a topic: common law spouse, pretermitted heirs. We'll have materials, training materials. We'll do an oral substantive training, and hopefully we're going to gather some steam, and we're going to start that after the first of the year. Try to develop the talent on both sides of the operation.
Thank you. One other question. So you had mentioned Supreme Court Rule 55 governs the new judge training.
It actually governs all judge training. So it's not only the new judges, but it's the ongoing training requirement for all judges.
Okay, because I saw continuing ed was under Rule 45, but I wasn't seeing, maybe that's the rule that you're mentioning? I just want to make sure that I'm looking at the correct thing. I see Rule 45 is continuing judicial education.
And what's 55? Something totally different? Did I put the
Yeah,
wrong?
it has about the public. We don't have a 65. It only goes to 62. 55 is Public Protection Fund.
Okay, I'd like to move to amend my rule to 50. It sounds like it's 45 is the rule.
Okay, so they're covered under both the continuing ed and the new judge. They both prescribe to this Rule 45.
Correct.
Thank you.
And that rule has been changed in the past few years. It used to be that there was a rule that all new Superior Court judges had to attend an out-of-state general jurisdiction training within X number of months or years from appointment. And the district courts and the probate courts, I mean, when I was sworn in February of 1990, and I went to court the next day in my new court, the Coos County Probate Court, and the Register of Probate gave me my docket on a yellow pad, and there was a coat rack with a robe on it, and that was my training. There's the robe, and here's your docket. Have a nice day. And I think we've come a long way from that through the evolution of the circuit court, because at least all I had to know was the probate, right? I didn't have to know everything. And now with the circuit court, when you're appointed to the circuit court under 490F, there's a presumption that you're able to do whatever we do. And the obligation is on me, I think, to make sure that judges have the training before I send them into the family division to do a marital docket. I have to make sure they have the skills that they need and that the confidence that they need to be able to handle those cases. And those are the ones they're most terrified of. The new prosecutors, when I say welcome to the circuit court and the family division, they take a deep breath, because they know that with that comes the cases we've talked about this morning, the JCC complaints that are virtually a guarantee that come with the territory. And, you know, the nature of those cases they're difficult cases, but everybody gets a share. That's just the way we work it.
Judge, in your training, your initial training, and you're saying that these new judges will be picking up some cases most likely before they have finished certainly their 6 weeks of initial training. Does that training involve having an experienced either judge or clerk, of which you have none, or some court employee in the courtroom with a brand new judge to both be there, perhaps for counsel, but more significantly to be there for evaluation and subsequent communication?
Yes, for sure. And what we have 34 court locations. Some are pretty small, but we have a lot of multi-judge courts, and we always endeavor to put the new judges for at least their first year into a courthouse where there are other experienced judges in the next chambers, because they get constant feedback. During the training process, the mentor judges, the experienced judges, will have a judge assigned to them, and typically the way they do it is it's watch one, do one. So they'll do a hearing. A lot of the judges are comfortable with just having the two judges up at the bench, and they'll explain to the parties what's going on. So let's say Judge Leary in Nashua, who's been doing this forever, will do a hearing or some hearings, and then the new judge will move over to that chair, and Judge Leary will sit beside him or her and watch and give feedback, and sometimes sit in the back of the courtroom for a few days and watch and observe and give feedback. That's all part of the onboarding new judge process. And like I said, we do, even before we send them to a courthouse, we do mock hearings in DV cases and landlord-tenant cases, just so they can sort of get the cadence of a hearing. Most of the judges that come to us have trial experience, which is one of the most important attributes, I think, regardless of what type of law you practice. So you know the rules of evidence, you know how cases proceed, you know how to move a case along, you know when somebody's maybe taking too long, and you can, with experience, push them along a bit. The judges that have not been in a courtroom are the ones that would be the most difficult to train, but I can't recall having one of those for a long time.
On your court, I can think of at least one court where there is a member of the judicial branch who I believe had no court experience before, but we don't have to discuss that in any detail right now.
Well, I was appointed by Judd Gregg, and he appointed one of his legal counsel who called me after I'd been appointed and said, Judd wants to put me on the Superior Court. I've never been in a courtroom. I don't know what to do. And I said, I'd take the position. And he turned out to be a very good Superior Court judge. He had literally never been in a courtroom. He was a real estate lawyer for not a long period of time, and he was a great Superior Court judge. He's long since retired, but it is possible. But you really have to study those rules of evidence and really get up to speed so that you have the confidence of the people that appear in front of you too, because I think people were skeptical. But we can train anybody if we are given the time and the resources to do it.
But I think your point might be that you're not given currently either the time or the resources to do, well, I don't want to put words in your mouth. My understanding is that you have indicated you could do a better job if you had more time and more resources. Is that correct?
Absolutely. We can always do a better job. And I think the resource, the resources that we have are the limitation in the number of, days that we can put in this. And if we had, most courts, I think, have a training person. That's their job, that they do judicial and staff training. And I think the Chief Justice would like to move in that direction. I think that's reflected. I didn't see the final version of the memo, but I think.
In the suggestion section? Would that be?
Yes.
We haven't gotten to that yet.
Okay. But absolutely, we could use more resources to train new judges. And to get back to, I think, a question that Representative Kutab asked about what do we do with the judges that are sort of half-trained? There are some core things that we do at the front end with every new judge. The first day, obviously, we get them fixed up with HR. They get their IT, resources, their computer, their laptop, those kinds of basic things. They spend at least a half day with me just pouring through the Judicial Code of Conduct. I think that's the very first thing we need to talk about when we go through it section by section. And as you can imagine, over the last 30 plus years, I have anecdotal stories about pretty much every section of the code where things have or could go wrong, and I share those with the new judges. We talk a lot about procedural fairness. We do a lot of training around just how to treat people that come in front of you. There's a lot of research that's been done, peer-reviewed research, that the satisfaction of litigants depends more on how they were treated than the result in the case. So somebody can lose a case and say, you know what, the judge treated me fairly, I'm good with that. People can win the case and think the judge is a real jerk. So we really want people to feel like they got a fair day in court and that they've been treated right. And so we spend a lot of time on that. And then if we have some judges that know, and I'll just give you a specific example, when we've had some judges that haven't had all of the substantive training, but they've got the basic trial skills and the basics of how to be a judge, because it is a different skill set when you get on the other side of the bench, for sure. And what we're going to do that this year. The new judges that are coming on board, we knew there would be delays, so we didn't build them into a schedule. We're behind on our small claims trials. Your constituents are probably telling you that because we're still catching up from COVID. We're going to do small claims blitzes around the state with these new judges. Just going to go in and, for a week, you're going to hear small claims cases one after another. We're going to try to chisel that backlog down in the bigger courts where those dockets can be full day, multi-day dockets. So that's our plan. And we've done that before with success.
I think I know, but I'd rather be sure. What is the dividing line on small claims now?
It's $10,000.
Thank you.
And between small claims and civil cases, that's about 20,000 cases a year. So it's a pretty good slug of business.
Thank you. Do you want to go on with your initial presentation?
I think I've kind of wandered around a bit. I was going to touch on the second bucket, which is the ongoing training for existing judges. We have 5 training days a year, and I'll call it's mandatory that judges go. We're fortunate enough to have some retired judges, like Judge Spath, who's not constitutionally retired, so she will do all of the arraignments for the whole state so that judges can be freed up to go. We have a judge who will be doing warrants for the day. And then every judge in the state gets emergencies every day. The judges have to bring their laptops to training, and they have to be available for the DV, the ex parte parenting, the child placement. So we take breaks during the day so they can check their laptops and issue emergency orders. But it's 5 solid days of training. Our next one is Friday, and we are fortunate enough to have some money from the Bar Foundation, which is a dedicated fund. We have Judge Sutton, I think I may have mentioned that in the materials, from the Sixth Circuit Court of Appeals, coming to do a talk on the U.S. Constitution versus the New Hampshire Constitution and how they interact. And I think it'll be a really good program. And then we're doing training at that event on the new protocols in abuse neglect cases. So it's a smattering of trainings, of all the case types that we cover spread out over the year, and judges can tell us what they need. We try to send all of our new judges within the first year or two to a national week-long domestic violence program that's put on by the NCJ, FCJ, the National Council of Juvenile and Family Court Judges, and to also an NCJ, FCJ program on abuse neglect cases. We got way behind during the COVID years because we had 20 judges that had come on the bench that didn't have that training. So what we did last summer is we brought the NCJ, FCJ judges to New Hampshire, and we did a multi-day program here, mandatory for the 22 new judges. And then Friday was a regular judicial education day for us, and all judges went to the third day of that. It was a great program. So right now, all of the judges have had the national training except the 3 new ones that are coming in.
Are there other points you want to share with us right now? No.
Well, I just think in terms of the tools, which I think does dovetail with education, in addition to the listserv, the training materials, we have an orders bank that is loaded with orders that judges have written on all case types. So, for me, I've submitted orders in the probate world on undue influence, incapacity cases, in the trust world, suppression issues in criminal cases, anything that's a well-written order, and we kind of vet them, go into the orders bank, and they're searchable by topic, they're searchable by, you can do a word search. So that's really helpful. The listserv is archived by the staff attorneys because the same questions tend to come up. So rather than reinvent the wheel, we have a, broken down by landlord tenant, whatever the different case types are. So people can go search there. All of the new Supreme Court decisions that come down are summarized and archived in there. And anytime that a staff attorney writes a memo on a substantive issue, that goes into a memos bank, and those are searchable by case type. So that's how we've made up for not having law clerks. That's kind of a virtual law clerk, if you will. And the staff attorneys, one of the staff attorneys' responsibilities is to make sure that those stay current. So if there's a memo that's outdated because the legislature's changed the law or the Supreme Court's changed the law, then we remove the no longer relevant materials and we try to keep it updated.
Chairman Pearson?
Thank you, Madam Chair, and thank you, Judge. No law clerks. Has this always been the case?
Yes.
Is there a reason?
Well, it's resource is the reason, but historically, pre-circuit court, we had the district court. At one time, there were 100 district court judges around the state. They were mostly part-time judges, and they just kind of did their own thing. And then the probate judges, there were 10 of us. We were all part-time when I was appointed in 1990. All the probate judges were part-time. The probate court was the first court to get a staff attorney, non-superior Supreme Court, which I thought was pretty clever at the time. I've had several, and many of my staff attorneys have become judges. But the Superior Court has always had law clerks, and the Supreme Court's always had law clerks. The Supreme Court has 11 law clerks. Superior Court has, I think, 15 or 16 law clerks. So it's about 1 law clerk for every judge and a half in the Superior Court. Supreme Court judges all have 2, and the Chief Justice has 3. It's certainly, I hear about it all the time from the circuit court judges that it would be a huge help. But again, we do what we can with what we have.
Thank you. Thank you. Kind of like those old TV shows I used to watch in the 50s where the judge rolled into town and he was a savvy old coot and he knew the law and he knew his people and he didn't need a law clerk. He was one to himself. I'm kind of hearing New Hampshire in a more northeastern way was a bunch of small town part-time judges doing things, and it worked.
For sure.
The state grew.
It was a lot simpler back then too, I think. The issues were simpler and the marital cases move much more quickly. We didn't have a trust code, so we didn't have trust litigation, which is what I do when I'm not doing the administrative judge work. I do the complex trust docket. And, for years, lawyers have said, many years, you need a trust, avoid probate, get a trust. And that's where all the litigation is. The litigation is in the trust world. And those cases are I started a case last week. It was supposed to be 2 days, and on the first day of trial, they said we need 3 more. We haven't even started the case yet. Those are multi-day trials. Some involve in New Hampshire. There's a lot of money in New Hampshire. A lot of money in New Hampshire. Had cases with multi-millions of dollars. The Tamposi case is the most famous one, but that was a 29-day bench trial in the circuit court. And the legal fees were over $6 million. So we do some big cases, which is why we need to train up some more probate judges, because somebody's going to take my place when I go on to greener pastures.
A follow-up on my follow-up, I hear ads on WBZ radio all the time. Don't lose your assets to a nursing home. You need to have a trust. And I know a number of people who say, well, gosh, does that mean a simple will isn't good enough anymore, you know? So are you saying trusts are more complicated than I might have led to believe?
There are certainly good reasons to have trusts.
Okay.
But it shouldn't be a will substitute in every case. When people have modest assets and typically you get the trust and then you don't fund the trust, or you put some of your assets in the trust, but you always forget something. So now you have an estate open and you have a trust open at the same time. So it doesn't make my life simpler as a probate division judge just because you have a trust, unless you completely do avoid probate.
Thank you.
And all this time, I thought this was a device by the members of the bar, not the bench, to be able to generate business. Am I wrong about that? You don't have to answer that
Well, I think
question,
let me
Josh.
just simply say this. I think you can charge more to create a trust than you can a simple will, perhaps.
Thank you. Yes, and the KISS principle, I think, always works. You have, if you are where I think you are, and we go to the suggestions section, you talk about a New Hampshire Judicial College. I'm not necessarily sure why you need something that sounds as highfalutin as New Hampshire Judicial College, as much as you might need a director of training or a department of training. I see that your hope is that it would be in the 26-27 budget, which would be, surprisingly as it sounds, the next budget.
Right.
We're almost ready to start asking. Do you have, and I know you don't want to commit to a particular number, but do you have any sense of what size, dollar-wise, that would be to make sense to do it at all?
So I don't know what the Chief Justice and I haven't really sat down with putting pencil to paper, but I think the concept is fairly simple, that we would, and I think that whatever we call it is secondary. I think maybe I don't know if college is too fancy a word, but I think the concept is we have a dedicated training person who is responsible for maintaining the training materials for the 2 trial courts, for putting together what are now our 5 programs a year, because we obviously do all of that ourselves, and that's pretty time consuming, for bringing in experts from the outside, because it's more, I think it's more cost effective, especially with airfare and travel and everything that goes with it. It's expensive to send even 3 judges to Reno for a week. Mm-hmm. Why don't we bring the resources here and do in-house trainings? But that takes a lot of time too. So I think the concept would be this person would manage everything having to do with training for judges and probably some of the staff training, using in-house resources, but also using exterior resources, whether it's sending judges to programs or bringing programs here. I don't see it as a big staff effort. At least would be my vision. I think it would be the New Hampshire way, but it would be someone who's dedicated to doing that, so that there's consistency and predictability in terms of timing and making sure that new judges get what they need when they come on board.
Maybe I'm being influenced by the fact that we're sitting in the very room where you would have to defend the budget to Division One. If you were given a pot of money, whatever the size is, we don't have to talk about that now. Do you think it would be more help to the effective operation of the court to have clerks and support staff, or to have a significantly enhanced training operation? I thought that would be an easy question for you.
I've sat in this seat for a lot of budget cycles. I've never left with a pot of money, but I think,
Well, now, wait a minute. Wait.
oh, I've done very well. I'm being facetious. I just haven't had that pot of money. Yeah, no.
I mean, I'm going to have Chair Leishman talk to you about this, so be careful.
No, we did. I'm very grateful for the last budget cycle for sure. We were very grateful. We got pretty much what we asked for. So I didn't mean to be flippant about it. But I think to answer your question, Madam Chairman, I think the availability of law clerks would be a huge improvement for the circuit court in terms of, as I said this morning, the quality of the orders and the timeliness of the orders, I think, would both go up. And I'll use this as a simple example. One of our judges posted an order, and this goes back a number of years, but it was a relatively new judge who was writing an order on a Fourth Amendment search with a motor vehicle, misdemeanor, okay, but it's still somebody could go to jail for it. And it was a half pager with one case, and just wanted to get some feedback. And the law was, I think, right, and there were enough facts to substantiate it. But in the Superior Court, that might have been a 6 or 7 page order, that a law clerk would have researched and written. And so to the extent we get criticized about our orders, it's part of it's a time crunch. And we tell the new judges this: you're not writing orders for, the Supreme Court every time. It's more important to get the orders out. And we see that in judicial evaluations. The judges that take more time to write longer orders often get criticized by the lawyers, at least, saying, you know what, I'd rather get a short order, timely, than a 6-page order that, that we have to wait 2 months for. And I get that. And every judge is different. The judges that stay off the overdue orders list are the ones that have figured out how to write a quicker order and get it out, rather than make sure that every single comma's in the right place and every piece of punctuation is perfect.
I'd like to go to, oh, I'm sorry. I see that you have something you want to say first. Go on.
I just wanted to follow on to that. I mean, I guess, what if it could be a tiny bit of both, and that you could get your training coordinator instead of a whole college, and then you could perhaps get some law clerks? Would that perhaps be a better direction? Because then if you've got the coordinator to put through, to organize all of the training for you, but then you've got some clerks that can help with writing orders, because we know that judges are currently writing orders from home, and they don't really have anybody and especially in the pro se family court cases, to kind of go through and help flag, hey, these are really important pieces that you want to make sure you look at in this file. What do you?
Sounds like a good compromise to me.
I think, thank you for that. I think some of what we're doing here is doing a little PR education, indicating you do not propose a New Hampshire Judicial College, because that sounds like next thing you know, you're going to build a building with columns in front. So be careful of what you call it. You just want a little New Hampshire. But another component of this, which is of concern to me, is what I call, and perhaps not precisely enough, accountability. It's one thing when a red flag goes up because something clearly was done that was inappropriate, in terms of whether it's the legal appropriateness or behavioral, whatever it happens to be. But that's going to be very few cases and very few judges. What concerns me is the routine accountability, knowing day in and day out that everything that you do as a judge is really sacred in a democratic society if we believe in this, and I happen to one who does, and I think you do too, so that it's even little things. It might be a question of demeanor. Do you realize that you are treating, let me give you an obvious one, that you are treating women attorneys in a way that's different from the way you're treating male attorneys. And it might not affect the outcome of the case, but it affects the public perception. And how do you provide routine accountability for those things that aren't going to end up getting someone removed from the bench, but could make the difference between a public perception of a careful, well-run judicial system and one that might not be so well-run?
Yeah, and that's a fair and a great question. And it reminds me of a conversation you and I had
10 years ago,
a
20
number of
years
years ago. Well, I don't know what you can tell me the year you were chair of House Judiciary, and and it was an issue about the ratio of women judges to men judges. I just want to, while I think of it, make the point that I'm very proud that with these last 3 appointments by Governor Sununu, we'll be at 47% women of our full-time bench will be women on the circuit court, which I think is great. But to the
Particularly
accountability,
since, as I understand it, coming out of the law schools, women are in the majority now. Is that
I've heard that. I've heard that. I think they're 37% of the New Hampshire bar. So if we're 10% ahead of that in our bench, I think that's a great sign. And I'm proud of that. But the accountability is hugely important. And first of all, New Hampshire is a small state. So we do judicial evaluations every 3 years, as you know, and we were on that committee together for a number of years. We revamped the survey instrument. Rarely do I get a judicial evaluation when I'm surprised. Well, let me just say that, because it's a small state, the lawyers talk, the lawyers and the self-represented people are not shy about either emailing me, mailing me, calling me when they have an issue. And it's so easy today, if I get a call or someone says, you know, the judge was rude to me or the judge did this or that, within a matter of, depending on what staff's available in the building, but usually within an hour or two, I can have the audio from that hearing on my laptop and I can listen to it, which is the first thing that the Judicial Conduct Commission does when they get a complaint. They call us. We have a good relationship. We send them the audio either electronically or on a CD, and most of the complaints go away because, no, the judge didn't swear at the person. The judge didn't raise their voice. But we do take that very seriously. And when there are issues, I either pick up the phone or I drive to the courthouse and have a chat with the judge. That's I think, an important part of my job, to make sure that those are nipped in the bud, especially with a new judge, that they develop good habits. So the judicial accountability evaluation process is sort of going on all the time in the circuit court, and I think the Superior Court does the same thing.
Do you wait for let's use a gentle term, a concern to be raised? Or are there retired judges that spot sit in different courtrooms?
So the short answer is, at this time, I do wait until I hear something. We have, going back to when Ed Kelly was the administrative judge, we have had conversations about using retired judges to just, and I think the new judges would welcome this, frankly, an experienced judge to just sit in the courtroom for a day or two, make some notes, and then go into chambers and say, you know, I saw this, I saw that. We did an interesting program probably 15 or more years ago, and Ned Gordon, Judge Gordon, then was one of the judges who volunteered, just put a video camera in the back of a courtroom, of a number of courtrooms around the state, including Ed Gordon's courtroom. And then we used those videos at a training for judges. And I'm not going to pick on Judge Gordon just because he's not here, because he's heard this before, but he was on the bench, and there were two hearings that came to mind. One was a domestic violence hearing, and when the victim was testifying, he was paying close attention. And when the defendant was testifying, he seemed to be not paying as close attention. And the perception to somebody watching that video was that Judge Gordon wasn't listening to the other side. And I know he was. And then there was another case that was kind of going on, and his head was down. And what he said he was doing was he was ruling on a stack of warrants that were on the bench. He was listening, but he was sort of multitasking. But again, if you're watching the video, your perception is, Judge's not listening to anything I'm saying. So that was very eye-opening for judges. We should probably try to do more of that. The video cameras are not expensive, and somebody's got to manage it and do it, but it's a pretty good training tool. But ideally, we would use retired judges who we would recognize as someone that would be good at it, to go watch new judges and provide feedback. The problem is they're all sitting for us right now because we need them. But I think that would be a great tool. I think you've referred to that as maybe a monitor or something like that.
Yeah. If I may, we had a conversation about my role as executive director of a medical center. When we get students coming in, I'm right on that to see, my gosh, today you saw 7 people with serious diagnoses, 3 of whom reminded you of loved ones. How you doing? And if we don't get on that right away and teach them how to be very present to the moment, but at the end of the day, put it in the drawer and go home and think of other things, you will either become cold and clinical, or you will self-medicate, or something won't work right for you and therefore your patient care. So I'm very keen on monitoring our young people coming through us. And again, just kudos to you. I raised the issue, I think I raised it with the chief, maybe with you. I'm familiar quite a bit with post-traumatic stress disorder in my work with the fire department. And if you have had numbers of traumatic experiences, maybe they didn't happen to you, but they happened to somebody and you were observing, there will be takeaways. And down the road, something will trigger. And you may not make the connection. It may be subconscious, but something will trigger a recollection back to one or more of those events, and you will act accordingly. And I'm just saying, especially in family court, where you're hearing all of these things all day, it may trigger something in the judge's own life or a loved one of the judges and so on. And I do encourage you along the way, as you're building your team of people for supervision and accountability, to have a mental health person who's familiar with that, to help judges watch for the signs in themselves as well.
Well, and that's a great comment. With the idea of secondary trauma, not only for judges, but for staff, is a real thing. And I can think of one instance specifically. I remember it well, a judge calling me on the weekend and had been managing this abuse neglect case for a number of months. And the mother was doing great. She was in treatment. She was, recovering, and he felt like he was having a positive effect on this family. And over the weekend, he heard that she had used again and overdosed and died. And he thought it was his fault, and he was very upset. And I was trying to walk him through and convince him that it wasn't your fault. And another time I had someone who works in our dictation center, where all our orders are typed, at judges that use the dictation center, and the staff person came in and was crying, and she had been following this family by typing orders. And all of a sudden she's typing away, and someone died from an opioid overdose. And it was just very upsetting, because she was sort of through the lens of these court orders following the life of this family that looked like everything's going to be okay, and all of a sudden it's not. So we are doing trainings around secondary trauma for staff and judges, but we can always do more.
Okay, thank you.
What about, I don't know how to word, what about R&R for judges who are handling these traumatic, difficult, painful cases? Is there any opportunity for a break in that in terms of the cases that they are handling? Or does it become impossible because you don't have enough judges?
No, I think we try to rotate judges, and if you remember back to when Ed Kelly and I testified in House Bill 609, our vision initially of the circuit court, our vision not really knowing what we were talking about because it came to be so quickly, was that there would be these 3 divisions, and you would be in the criminal division for a rotation, a year or 2 years, and then you go to the family division, and then you go to the probate division, and it sounded good. In practice, it doesn't work except in the very largest courts, because all of our medium and small courts just have to do everything. But we do take judges off the family cases for respite from time to time, put them in the criminal division, put them in, hopefully we'll attract some to the probate division. But there are judges like Judge Lemire, who is very good at family, and that's what she wants to do. And frankly, I haven't tried to talk her out of it, and she takes on some of the more difficult cases. That's just her wheelhouse. She signed up to be a marital master knowing the work, and we have a few of those judges that I'm grateful for.
So regarding the having the camera and giving feedback, I visited the Manchester court and I realized that there was the security team had video of the courtroom that was going on as well as audio that was going on. So I guess in the courts that do currently have that going on as part of their security system, would that be something that perhaps could be reviewed from time to time, just, to see if, things are being checked into, I guess?
So the video cameras are video only for security. The audio is the record from the court. So to marry the two up, I'm not sure that would work. So the cameras that you see in the lobbies and in the courtrooms are not recording audio.
Man. So in Manchester, they were playing the audio in the lobby, though, of one of the courts that they were watching the hearing at the same time. Are you saying that even though the audio was playing, that it wasn't recording?
It's recording on the FTR, the for the record recording equipment in the room, but that's not a camera that's recording contemporaneously. So you'd have to match.
There was audio outside of the courtroom, though.
It would be coming through the PA system that's attached to the microphones, but not. I'm not sure. I mean,
It's not recorded, so it was through a PA microphone. Okay.
Right. The videos are important, though, if we have, typically security issues. If something happens, an altercation in the courtroom, that's really why those are there. Those are there really for security, not for video recording of the hearings.
So there is no audio on those video recordings, though?
Correct.
Thank you.
Even in the lobbies, it's not audio.
We want to help. I think you know that. I think I wouldn't be part of anything where we didn't want to help. Do you have any specific suggestions that you would like to make either now or in another venue at another time where you see what the legislature could do to help? Because there are two categories. There are things where the legislature might say, of course, this falls on your turf, but it seems to us that you might want to try X, Y, or Z, where we have no authority to pass legislation, nor should we. But representing the citizens of the state, we see some things that maybe you should look at. That's one category. Then there's the category of things that clearly fall on our side of the line, and we're working with our legislative colleagues. We might be able to help you do even better in delivering justice to the citizens of the state. And I think that I know a majority, and probably it's all of the people on this special committee would like to do that, would like to do what we could do to make it better. Now, you might not feel ready to do that right now. You might not want to use this particular audience to do it. But I would like to very formally, from this committee, you know, looking at training, education, supervision, and accountability, all of which I think address the quality of the delivery of justice. We'd like to know where you, who know this much better than we do, would make some suggestions.
So I am grateful for the invitation. The way the branch operates is that we work with the Supreme Court and we formulate our asks through that mechanism. So I will certainly, and by the way, the Chief Justice, I think, wanted to come this morning, but they had oral arguments. So he was aware that we're here today and I think would have come but for that fact. So I will definitely get together with him and the administrative council and come to you with some suggestions. I think probably a lot of which we've already touched on today in terms of, I just hate, you know, it's hard to come here and keep asking for more because you did give us what we asked for this year. We asked for upgraded labor grades for our staff, for more staff positions, and we asked for more judges, and we got that. And we're trying to do it incrementally so we don't ask for too much at once.
That relates to money. And of course, as you've heard me say any number of times, when they say it's not the money, you know it's the money. But there might be other steps that we could take through legislation. After all, we created the court in the first place. We know none of those courts are in the Constitution.
Right.
And so there are, these are things that we can do if we chose. And I think we would be more likely to choose if we knew that those who know the most about the delivery of justice could see ways that we could do this better. And we would like to do that. So it's a question of working together.
And we're happy to do that. And the fact that this committee exists is a concern to me, just because there's a perception that that there is a problem. And to that extent, I want to be able to be part of the solution.
I think that's true. I think we know it's true. We see, I don't serve on Children and Family. I serve on Judiciary. So that it's only by observing across the room that I see the bills that come in to Children and Family, and whether they are justifiable or not, whether the questions that are raised are verifiable or not, is irrelevant. In the system that we have, any legislator is free to file as many bills as they choose. And one would hope that these bills would have been well researched before they file them, but that is not a requirement. And in many cases, a legislature files a bill because someone asked him or her to do so, and then drops that bill on the committee desk and expects the committee to make gold out of chaff. And that's not the committee's responsibility either. Chairman Pearson struggles with this, and it's out of all of that because he wants to do the right thing. And out of that this committee was formed. Mm-hmm. And I think we have succeeded, I hope we've succeeded in putting many of the concerns in appropriate perspective, recognizing the pain, the distress, the unhappiness that any individual might feel, but also recognizing that that's not necessarily affecting or reflective of the entire court. And so what we want to do now is say, okay, what can we do working together to make it better? And so I hope that you will not just wait and think that, oh, well, they're sure to see what needs to be done. Because that's, as much as we would like to, we have 800 bills, you know, and
A couple of things. Number one, you can say to the Chief Justice that I certainly forgive him for not being here, because the last 3 times he and I were together, he gave me a law book each time, and I'm 2 books behind, and I just need a little bit more time myself. Secondly, the etiology of this committee was that we had some bills that came to children and family law that, let's just say, it didn't look like the judicial system that I know a little bit about. And I spoke to the speaker about it, and he said, let's form this special committee, and in part, it will get bipartisan and across the age span, and freshmen and veterans and so on, all looking at the different topics and coming to our conclusions as to what we think the judiciary is doing, which I think most of us think it's doing pretty good, but also use the occasion to say, hey, let's have a dialogue about how we can make a good thing better. That's the initial conversation I had with the speaker that led to this committee being formed. And that's why I'm taking this and a collaborative and not antecedent and that one manner.
You will never hear me say we can't do things better.
I know.
And I'm open to suggestions, and I'm excited about the opportunity to collaborate and try to come up with some solutions that we can, that maybe don't cost money, but that will help the system.
Representative.
So, yeah, I mean, I believe I heard you talk about 2 areas that maybe did cost money, and that was the, judicial training coordinator and then perhaps the law clerks. And I think, and I don't want to speak for her, but I think what our Madam Chairwoman was also discussing was if there's any policy areas that perhaps if the policy areas were looked at a bit, if that would enable you to perhaps improve the quality of justice that's coming out. Is there anything that's kind of tying judges' hands where they're like, hey, I really don't think this is fair, but I have to issue this order because that's the way that the statute's written. So if you can kind of think about that in some ways, and I do think, if we're making some recommendations out of this committee, and certainly some things are always about the money, and we can't have an unlimited bucket of money, but I think we do have some leeway for some things if they're really urgent and we do need to do them, that we wouldn't necessarily have to wait until the next budget if something was really needed. So I kind of wanted to put that into perspective.
I do want to make clear that that last comment has not been discussed with Chairman Weiler.
Well, actually, it has, Madam Chairwoman, because I see him at least weekly, and the subject of what I want him to do in the next budget for the judiciary is an ongoing conversation.
It's the next budget, not this budget.
Okay.
I will say that when we were here for Division 1, Chairman Weiler sat in that chair, and I reminded him that he was chair of House Finance when we created the circuit court, and we made a lot of promises, and I think we kept them all in terms of the multi-millions of dollars that we cut and have continued to save. I feel a little bit responsible. I think we cut too deeply at the time, and it's a lot harder to get things back than it is to give them up. But with that said, the legislature's been very good to us in the last few budget cycles, and so I have no complaints about that.
I remember touring the telephone center all those years ago.
And we've taken 5 million calls. And we didn't lose a call during COVID. Even in that first week, we moved people out with their cell phones, and we didn't drop a call. So that's a success story, too, that I'm very proud of.
We have taken so much of your time today, and I feel really guilty about it, because justice delayed is justice denied. But is there anything else that you would like to share with us now?
No, just my thanks for all of the work that you've done. It's pretty remarkable about you know, how much time you spent over the course of the last few months listening to testimony about the circuit court. And I am supposed to be at another hearing at 2, so I'll
Okay, well,
Be a
we
little
don't
bit-
want to delay you.
fashionably late for
Do
that.
you need a note from me to say that it's okay that you're a little late?
I might have to come back to get that, but I'll s-
Okay,
I'll
you
s-
know where, you know where to find me.
Yes.
Oh,
Thank you very much. Thank you. So we're going to.
right around the corner. The subcommittee is over for the day.